All right. Well, welcome to the City Chambers. We're going to be starting basically now to begin the Committee of the Whole meeting. There's quite a few slips that have been turned in for public input. So we'll get to those. As you know, you can fill out one of these yellow slips to take 5 minutes and speak before the City Council. Okay, so my name is Dennis Roberts. I'm the 5th Ward Alderman. I'm going to lead the event tonight, the committee meeting. So I call the meeting to order, and would the clerk please call our roll?
Ms. Barnes?
Here.
Mr. Bowersox?
Here.
Mr. Gehrig?
Here.
Mr. Lewis?
Present.
Mr. Roberts?
Here.
Mr. Smythe? Here. Ms. Stevenson?
Present.
Mayor Pressing? Here.
Okay, thank you, Phyllis. Are there additions to our agenda tonight? I see Libby Tyler moving forward. Or are there any changes in our agenda? Okay. Is there a staff report? Maybe that's what Libby Tyler is about to tell us. Libby.
Just an announcement, which I'll pass out here. There's a Carl neighborhood meeting tomorrow night. That's Tuesday, December 9th, 6:30 to 8:30 at the Pollard Auditorium, the Forum at Carl. And this will be a report on campus modernization project, concerns and input from neighbors, and a presentation regarding your children's safety and community successes at injury reductions.
Oh, okay. Thank you, Libby. Okay. All right, so we're getting this memo actually passed out to the City Council members. It's just the announcement that was just read, I believe. Okay. Bill Gray, staff report, sir.
Yes, I have one item to announce. This is very recent information. Today's mail, we received an award. It's called a 2008 Honor Award for Planning and Urban Design. This is recognized by the American Society of Landscape Architects, the Colorado chapter for the Boneyard Creek Master Plan. So Wank, whose home office is in Denver, Colorado, applied for this honor award and received it from the Colorado chapter, American Society of Landscape Architects. So
Wow.
Something more for our walls here. But anyway, this is nice recognition for the Boneyard Creek Master Plan. So just thought I'd bring that to everyone's attention.
It wasn't a monetary award, so we could build the plan out faster, right?
I think that's still in the mail. But,
Great.
We'll be looking for Mr. Postman. Is there a motion to approve the minutes of the meeting dated November 10th, 2008?
Second.
Okay, Heather Stevens and Lynn Barnes. Are there any changes or corrections to those minutes? We don't see any. Those in favor of approving the minutes as indicated, please indicate so by saying aye.
Aye.
Those opposed? Okay, the minutes are approved. We have a series of public inputs, but before we turn it over to the public itself, we have a proclamation which the mayor will explain.
Okay, this is our 175th birthday, and we've asked different people in Urbana and institutions to help us celebrate. And I have a proclamation in honor of a church. Whereas the city of Urbana is a city founded in 1833 by pioneers from many cultural, geographic, and spiritual backgrounds, and whereas First United Methodist Church of Urbana, originally known as Methodist Episcopal Church, erected their first building in 1840 using logs felled by church members and cut to length at the Busey Sawmill, and whereas the congregation's first brick church was erected at 304 South Ray Street in 1856, And whereas the current stone structure was dedicated September 11th, 1927, and continues to serve the United Methodist Church community of Urbana. And whereas September 5th, 2008 marked the 172nd anniversary of the First United Methodist Church since its founding in Urbana in 1835. Now therefore, I, Laurel Lunt Pussing, Mayor of the City of Urbana, Illinois, do hereby proclaim Sunday, December 14th, 2008, as First United Methodist Church Day in the City of Urbana, Illinois. And we have the pastor of the congregation, Reverend John Sims. I'd like to give you the proclamation. And congratulations.
United Methodist Church for Urbana and the City of Urbana pretty much have grown up together. We continue to support this vibrant community, and we will continue to serve the spiritual needs downtown.
Thank you.
Thank you. Now we go on to the public input, and there are individuals who have indicated that they would like to speak on topics before the topics appear on our agenda. And just going through a list here, we have E. Wayne Johnson. If you would step forward at 1810 South Vine Street and explain, you have five minutes, and please be succinct.
Thank you very much. I live at 1810 South Vine Street in Urbana, and I'm here to speak about the proposed ordinance in regard to criminal nuisance properties. I think that this ordinance is ill-advised. I think it's bad for several reasons. First of all, I don't think that it improves the general goodness of our community. It's not for the general good. It is another part of what we consider to be the hand of the police force, more authoritarianism. It starts out by saying that a home rule unit may exercise any power and perform any function pertaining to its government and for the affairs for the protection of the public health, safety, moral, and welfare. But I'm reminded immediately that Tolstoy advised us. Sometimes you read Tolstoy, you think that he lived in our time. And he said that you only need to admit that public tranquility is in danger, and any action finds a justification. All of the horrors of the Reign of Terror were based only on solicitude for public tranquility. And we consider our time and the things that have been foisted upon the people in the names of public security, the Patriot Act, the so-called Patriot Act, the FISA Act, the Department of Homeland Security. Are we any better off because of any of these things? That how many of us want to have the government looking through our sock drawer, have us under surveillance all the time? This is, I think we used to call it Big Brother. Maybe we should call it Big Sibling now. The city asserts its rights to authority. We know about how the city manages authority. The city of Urbana has a reputation for its authoritarian hand. There is generally no apology given. I saw last week apology was given for authoritarianism, but most often there's no apology. Where is the place for this in a small town? I thought that small towns were supposed to be friendly places. Why do people move to small towns? I think it's because small towns are supposed to be friendly. Urbana's logo says that, one of the logos says it's a fertile ground for mind and spirit. As a veterinarian who has worked with cattle, I'm aware of what sort of activity makes soil fertile and what makes the grass grow green, as the old song goes. And whenever I've talked to people about this ordinance and they expressed what they thought about it to me, I don't think that's the sort of fertility is what the slogan maker had in mind. I think the idea here is to foster creativity, but I think that it's futility to try to establish creativity by putting our people under surveillance. There really is a valid role for government, believe it or not. We must have the rule of law to protect our basic rights to property and to ensure that we don't overstep our personal bounds and to not do harm to one another. But when the government oversteps its bounds and begins to beat the sheep and harass the citizenry in numerous ways, things are not right. We don't want to be treated this way. Another reason this proposed ordinance is wrong is it is misdirected. It's directed at the properties and the property owners. It's not properties and property owners that commit these crimes. It's the people that do these things. The ordinance says encourages or permits a property to become a nuisance property. There's a long way between encouraging and permitting. There's a lot of things that we can do without getting someone's permission, and the only way to stop people from doing these things is to put them under 24-hour, 24/7, 365 surveillance. And indeed, Part C says that fails to implement reasonable and warranted measures as specified by the police chief. This seems to be recruiting the landlords and landowners to be members of the police force, and I don't believe at all this is why people go into the business of renting apartments to people. But overall, I think that this will, if this is implemented, it will decrease property values in Urbana. It will drive away creative and entrepreneuring people. It will enhance the negative reputation that people already have about this city. And it's not what I want for my town. So I urge you to vote against this very negative ordinance. Thank you very much.
Thank you, Wayne. And that was just within 5 minutes. Also wishing to speak before the agenda item is Mr. Belton Field. And then when you approach the table, let us know who you are and what your address is.
Belden Fields, 206 West Pennsylvania, Urbana, Illinois. I want to speak briefly about two issues. One of them is the same thing that Wayne Johnson just spoke about. I think that one has to be very careful with these, and there are two things in particular that I think need to be thought through. One of them is the issue of collective punishment. That is to say, there's a huge difference between an apartment, let's say, being rented by drug dealers in order to use that as a base of operation, and a situation in which a member, let's say a youngster, teenager, gets involved with drugs or gives drugs to somebody else in the apartment, but that's not what the apartment rental was really all about. And to evict a whole family or expect a whole family to be evicted because of the behavior of one member of the family is not a good thing to do. In fact, it's regarded as a human rights violation. Call to your attention the Israeli policy of destroying houses because a son of a family or a daughter of a family engaged in an act of terrorism demolished the whole house and the whole family is left without it. So collective punishment is something I think needs to be given certain thought. The second thing is this should not be applied arbitrarily. It shouldn't be drafted so loosely that it can. In other words, some people doing the same thing are not touched, but other people are touched. That would violate equal protection of the laws. And I think that has to be thought about very carefully. The other thing I want to talk about is the Employee Free Choice Act and the resolution, and I congratulate Charlie Smith for proposing support of that. What we have seen in the United States, most unfortunately, has been a strong decline in the rate of unionization. And that's due to a number of causes, to be sure. It's due to moving manufacturing industries from the north to the south. It's then due to moving manufacturing from the United States to other countries where unions are not permitted to exist or are strongly controlled, as in China, by the government. But it is also due to a very aggressive war against unions in the United States by employers and by certain political administrations that we have had. The fact is that in the private sector, we're down to just below 7% of unionization. When I was doing work on these issues in the 1970s, our total unionization, government and private, was in the 40s. It is also true that as unions have vanished from the scene, we have also had a decline in the real income of workers. That even as worker productivity has increased. At the top of the scale, if you look at how CEOs and management are treated, even when they perform badly, there has been enormous increase. This is partly caused of the wage gap, the enormous wage gap that we have in the United States. Now, people who try to form unions are too often fired in the United States for the union activity. They surface because there have to be open elections. When that is seen, too often they are fired. They are harassed and they are fired. They should have recourse. What is the recourse? The National Labor Relations Board. It takes so long, years and years, to take a case to the NLRB and to argue your case in that if you were out of a job that long, you wouldn't be existing anymore. So this is, as I'm saying, there is a very, very heavy, has been a very, very heavy campaigns against union, and much of it has been illegitimate and illegal. But the recourse has been so extraordinarily difficulty that it might as well be legal. We need something like this Free Choice Act where the people don't have to surface publicly and then get picked off by employers and lose their jobs. Thank you very much.
Thanks, Belden. Mike Lehman would like to come and address before the agenda item comes to the attention of the council.
Hi, I'm Mike Lehman, 608 East Green. I'm here to talk about two things. The first one just briefly, and to note that probably the Prairie Greens do support the initiative. I believe it's your agenda item 11 that to provide financial reporting on the internet for the city of Urbana. We're, of course, have spoken to this particular issue before. Of course, after the township meeting earlier in the year, for this to sort of come up again, I don't know, several adjectives jumped to mind: ironic, weird, or bizarre, because the people could have spoken strongly on this last month if they'd been given an opportunity. But I think that pretty much you will find people in Urbana supporting this idea. I'll turn now to it's item 12 on the agenda, the Employee Free Choice Act. And like Belden, I'm here to, and also here to speak on behalf of the Greens in support of this. And this is something we may find more common agreement with together. I'll only speak to perhaps my personal circumstances here, because sometimes these things seem to be just good ideas or something that seems to be purely theoretical. Almost a decade ago, I came and appeared before the council because I was with a number of other people who worked in what used to be the transportation department up at SuperValue, one of our main employers. There had been an election, union election up there for the drivers and the mechanics, and it turned into a long disputed union election, and typical of all the bad stuff that you hear about these things. There were a number of things that went on during that union drive. They say that 75% of employers hire consultants or union busters to help them fight organizing drives. SuperValue did that. 78% of employers that force employees to attend one-on-one meetings against the union with their own supervisors. SuperValue did that. 92% force their employees to attend mandatory closed-door meetings against the union. SuperValue did that. Companies that threaten to close the plant if the union wins the election, 51% did that, and SuperValue sure did it. One of the interesting things, and perhaps a little bit of a hopeful sign, is that actually only 1% of companies actually close their plants after a successful union election, although somehow SuperValue managed to even partially accomplish this, because they decided after this thing was settled that out of 28 divisions, their division here, which was always one of the lowest cost divisions, the first 3 lowest cost amongst them, they decided suddenly it was uneconomic, and they contracted out our jobs. I didn't happen to be in the bargaining unit, but I was affected because I was the parts clerk in the garage, and I've since returned to college and still trying to get my butt out the door at the University of Illinois one of these days. But I can only speak strongly in favor of this, given my own experience, the experience of other workers in our community. The U.S. has, amongst industrialized nations, one of the weakest labor laws. We have lots of law, but it's incredibly weak. Companies deny breaking the law, but are rarely held accountable. We have a case up in Chicago right now where folks are sitting in where, once again, the law is pretty weak. We'll see what happens. People are upset. The economy is kind of going in the tank. And unfortunately, I think this is, as Belden reminded us, in part because of less unionization in our country. And this creates a problem because workers need to have a good, strong voice. We've got the kind of government perhaps that we deserve, and that may be why we're in this mess right now. We can only hope that it gets better. So I will strongly support EFCA. I appreciate Mr. Smith bringing it up, and I hope you all will support that. Thank you very much.
Okay, we have 2 questions. Michael?
Sure.
Okay, getting back to the original topic that you discussed
Yes.
about the financial reporting.
Yes.
Are you aware that we have that reporting on the internet?
Yes, I am.
Okay, so then, why, we said that we would put it on, and there
Sure.
was no need to have a referendum, and we put it on, so what is your
I
concern?
believe the question was a wider question than merely financial reporting, as I recall anyway. But that's subject to interpretation. That's your interpretation. I know the folks that wanted to have that on the ballot had a different interpretation of that. Perhaps it would have been best to leave
Diana
citizens decide
Visick
that.
said she withdrew the ballot question at the town meeting because I assured her that we would put it on the
Sure.
internet. And
Yeah,
I want you to know that Urbana has for many years been putting financial information available. So I want to ask you, have you looked at the information?
Oh, sure. I've used the website quite often.
Okay, did you find something of interest? Do you like it?
Well, I think it's a great idea. Actually, I ran for county board here earlier this year and used that quite frequently for keeping up with things out there. I think it's a good idea. I totally support it. I think it's always best, though, if you can get input from the public, that's a good thing. And I really don't see what the issue was with that. So,
I guess the issue was that we were going to do it anyway. If anybody asked, that was the only issue.
And Heather,
Okay,
did you?
thank you.
Okay, thank you. Okay. We have, okay, let me look. Okay, so that, I think, covers those individuals who wanted to speak before the items came up on the agenda. So we're going to go now to the agenda. And there's no other input from city council members at this time, right? That's public? All right. Okay. Okay, the first item on our agenda is an ordinance number 2008-11-135, an ordinance amending Chapter 15, Articles 4, Division 1 of the Urbana Code of Ordinances, criminal nuisance property. And we have, we'll have a presentation by our legal staff. We do have several people who want to speak to that issue who've left their slips. But let's first have a presentation by.
Well, essentially, I've already given the presentation when I first rolled this out to you. I would just add that what I passed out to you, in addition, is a lease addendum for drug-free housing. It also references other criminal activity. It is something that an example of the type of language that we would encourage landlords to utilize in order to keep their rental property crime-free and drug-free. However, I want to emphasize that this ordinance is not designed solely for rental properties. It is also designed for owner-occupied properties and commercial businesses as well. It refers to any property in the city limits, and that means that it could be a store, a bar, a gas station, a home. People do sell drugs and engage in criminal nuisance activity right out of their very own houses. I've also handed out to you some material that's been around for quite some time. It's the Schaumburg Crime-Free Multi-Housing Program and Residential Rental Ordinance. I'm sure some of you might have seen it before. I wanted you to have it because it has some good information, albeit some dated articles, but still some good reading to help frame some of this conversation regarding this. And the last handout was the landlord training program. It was originally created for the city of Portland, Oregon, by Campbell DeLong Resources Incorporated, and it's just what the title says. It's a practical guide for landlords and property managers, and it's a community-oriented property management approach. And it talks about not only keeping the property safe, but also habitable, and keeping the upkeep, maintaining the upkeep of properties and so that they are livable. So I just wanted to put in your hands some more resources for you to look at, so that you can, if you do a thorough reading of this very basic material, it might inform how you frame this issue. Last time we were here, when this matter came up a few weeks ago, we left it at that we were just going to continue it to the day to give you all an opportunity to study the issue and to, formulate questions, if any. So I'm here to answer any of those if you have them.
Okay. All right, let's just have our questions, I guess, first. All right. Well,
Or comments.
Comments or questions?
comments are-
'cause-
this is for the lawyer, our lawyer, Ron Neal.
I asked
Laura Preston.
Ron O'Neill to draw this up. I had been to the Illinois Municipal League way back in 2005. That's my handwriting. And what we've learned, what the police department tells us, Chief Bealey, you can ask him, the most significant thing in reducing crime is the management of a property. And that was one of the reasons why we passed rental registration, was to make sure that property was safe, from a physical standpoint. And we've reduced crime in certain apartments that had very high crime levels by pressuring people in the courts and getting new management. And that's one of our ways of dealing with it. We did try, at the very beginning, we succeeded in adding 5 new police officers, but we recognize that this is not just a police issue. The city is trying to do every tool at our disposal to work on the crime issue, because all cities have crime, and people in Urbana don't expect to have any crime here. I don't know of any cities that are completely crime-free, but we're trying our best to reduce it. And the kind of comments that I got were concerns like Belden expressed, that innocent people would be thrown out. And I wanted Ron O'Neill to comment on how this actually worked in the city of Aurora. And I think that the city of Champaign also has this. And when the people emailed me, I asked them to give me some examples of realities of what they're concerned about. So would you please comment on that, Ron?
Sure. That's a common concern, and I understand it. We certainly, in correcting a criminal problem, do not want to innocently displace people. However, I never hear anyone commenting on the people who live there that have to live with this type of activity. Most, not all, but most of the people that I've heard from are people who have the resources to leave a situation. In other words, if somebody is dealing dope next door to them, they can move. So while we have to look at the possibility that somebody might be displaced, I want to frame it in a proper context and let you know that this is no different than if a building was condemned and it had residents, and one of our inspectors came and said, this building has to be vacated, it's, collapse is imminent. What would we do? It would be the responsibility of the city to slap a sticker on that building and say it needs to be vacated, it's unsafe. The landlord has a written agreement, the lease, with the tenant, and if the landlord fails to do something or does something that causes him to be or her to be in breach of that lease, I believe that the landlord has a responsibility to assist those tenants who are being displaced, particularly because of a nuisance, in helping them find new housing. Now, in one other community, I believe it was Joliet, the city, the one time they did have to close an apartment building, and there were a few residents that were going to be displaced. and the city provided some assistance in helping them find a new place to live. But for the more important and a more essential issue is that closing a building or an apartment is a very drastic measure, and it is only done after all other attempts to try to get compliance and to cause the nuisance to be abated have been tried and failed. So on one hand, yes, I think we do need to consider if somebody innocent would be displaced, but on the other hand, it's a weighing and balancing. I mean, if we have a building or an apartment or a house or whatever that has become a crack den, or there are major drug or narcotic sales taking place there, we do have to weigh the interests of the person living in that building or in that house against the interests of the entire neighborhood, and in a larger sense, the city. If reasonable attempts have been made to close down that activity and to get the landlord or the property owner to abate it, and take reasonable measures, which, by the way, would want to work with the landlords to try to help them come up with ways to do that, and we have not been successful, what is the answer? I mean, the police can keep coming and making arrests, but some of this is not a police issue. It's not a law enforcement issue. The person's being arrested, but they are continuing to terrorize people who have no choices and continuing to deteriorate the quality of life for people who have to live around someone who is stuck on stupid and has just chosen to live that lifestyle. With regard to Aurora, we had to close the building exactly 0 times. Just never got to that. And I don't know too many communities where it does get to that. Essentially, what happens is the only time a building gets closed down and anybody gets displaced, there's a whole laundry list of things that are going to occur first. First of all, typically the city, through its property maintenance department and its police department, are probably going to have a number of conversations with the landlord to make them aware of the problem and to offer some solutions, which the landlords are thereby going to have to ignore. Or they'll make some feeble attempt to correct it, but it certainly won't be an effective attempt. After that occurs, 2 or more incidents of criminal nuisance activity have to occur within 6 months, and they have to be verified by the police. Even then, it's not necessarily triggered. The police officer or officers would then, in consultation with the legal division, which is me and my colleagues, we would have to sit and take a look at what efforts have been made. Usually before filing anything, I personally make an attempt to try to mediate a solution with the property owner, and that entails me calling them or writing them a letter and inviting them to a meeting. Usually I try to have me or someone else from legal, as well as a property maintenance or inspector, and a police officer, particularly the officers that may be most familiar with the geographic area. And that is the meeting where we basically, draw the line in the sand and say, this is an ongoing problem at this property. You've been made aware of it. You've received phone calls and letters. You are now getting this meeting. We need you to do X, Y, Z now. And if we see good faith effort to do the things that need to be done or may be suggested or that would be reasonable, we back off and just monitor. If we don't, and sometimes that happens, or if we see an initial push to do certain things and then the property owner starts to back off, or there's an increase or continued criminal nuisance activity, only then do we, go forward with a violation of this ordinance. When that happens, typically the first time is a fine of some kind, and it's usually going to be a pretty stiff one. I think I've put in here somewhere between $300 and $750 for offenses, and the fine is graduated. It'll go up if you have second and third and fourth offenses within a certain time period. After the fines, if this activity continues, or the property owner or landlord continues to ignore the issue, and this type of criminal nuisance activity continues, then we'll bring back and have an increased fine. It is only when we get down the line and we've tried everything, and the property owner or the occupants are refusing to cooperate, or at least not cooperating in good faith, and in consultation with the city staff, there's a determination that the activity at this property is having a material impact on the neighborhood or the other members of that apartment complex or other businesses in that strip mall or whatever the case may be, then we might seek to, at least in the way the scheme for this ordinance, it would be to possibly not allow that building to re-register the following year under our rental registration ordinance, and thereby they would not be able to rent their apartments. There's a lot of flexibility in how we draft this language. Some ordinances, they give the city the power. In Aurora, we could shut down an apartment building, a complex, or a whole complex. It's, if it was in the instance of a residential area. Same thing in a strip mall. If there was a problem with one store, we could close that store or several stores if they were all part of the problem. We're also not doing anything differently in a sense than what the state of Illinois already does. There are already drug and crime nuisance ordinances or statutes on the books, and the state's attorney or the attorney general, and in some instances even a private citizen, can file an action to basically have the court seize a property, and it's been done. The court will seize a property and order the sheriff's department to go out, vacate the property, and secure it against all unlawful entry. And essentially that property owner loses the use and enjoyment of that property or the structure. If there is no structure and it may be just an open lot that a lot of criminal activity is taking place in, it may entail something akin to, as I may have mentioned before, constructing the 10-foot construction site fences around the place so that the lot may not be entered. So in summary, I've heard this concern before. It never really gets to that, because most property owners, at least commercial and rental property owners, are business people, and it doesn't make good business sense to have the city scrutinizing you and you having to pay some fairly substantial fines. Because remember, each day, each incident, and each day that incident occurs is a separate offense. So you can imagine where activity is going on day in and day out, and we verified it through police investigation, and we've determined that it has occurred, and then us seeking $300 to $750 for each of those incidents. So the reality of what has been presented generally in terms of, here's our worst case, our worst fear, I've never seen that fear come to fruition. I haven't seen it, and if I'm not saying it couldn't be a disastrous situation, but I promise you, if there is a situation where we had to close down an apartment building, something extraordinary is going on there, and you would probably know about it ahead of time and even support closing it down, because that's how bad it would be. I wasn't here at the time, but I understand that there was a university in Cunningham. There was a hotel there at one time that had some bad criminal activity, much like what we are talking about here. And something like that would be an opportunity to use this ordinance to try to force the property owner to control who they are allowing to live there. We don't want to discriminate in granting housing But just because we have an ordinance to say you cannot discriminate against someone based on their criminal status does not mean that you are obliged to allow criminal activity to continue on that property. So you can have as part of your lease that all tenants must obey all state, federal, and local laws, and violation of any of those may subject them to eviction.
Thank you. We do have some public, members of the public who want to comment, but maybe I'll hold that for a second. I would like to take any questions that staff or the city councilman have specifically to Ron before. This is not discussion for us among ourselves, but this is any question you have, legal questions to Ron O'Neill. Okay, Brandon.
Yeah, I have a couple questions. I'll hold the other comments or suggestions, but just ask questions. First, Ron, is there any legal way that a landlord can evict one person rather than emptying out an entire unit, so that if there's a criminal using a unit to deal drugs, but his grandma lives there or her grandma lives there, that we're not affecting the grandma or the aunt or the children or the other unrelated people by clearing the whole unit? Can we evict?
When you say unit, do you mean like, say, an apartment building or just an apartment?
Even in an apartment, if 4 people live there, one of them we've proven is part of serious criminal behavior that is a nuisance to the neighborhood, and the other 3 are the grandma and the aunt and the child who are not part of the criminal behavior. Can the landlord cause some eviction of the?
Who's on the lease? And the reason I ask is that's important. I mean, if you have a situation where you have several people who have signed a lease who live together, and there's only one of them causing a problem, maybe it probably depend on how the lease was drafted and whether you could evict one person and leave the other. More often than not, there's one person on the lease, grandma, and it's grandma's grandchildren or children or whoever who are causing the problem. They're not even on the lease. They're not even supposed to be living there. Most modern leases say that you can't have people living there who have not already been vetted by the management or owner of the, if you're smart, that's what you have there, so that you don't have one person signing a lease and then 5 other people you didn't know about move in and possibly start causing trouble. So I don't know if I answered that question, but I guess I'll give you the legal answer. It depends.
Okay. Second question is regarding the burden of proof and sort of the level of proof. We're not just taking action because of calls for service. It looks like, at least from the wording in the lease addendum, that the lease addendum for drug-free housing, that we would ask landlords to put in their leases.
Something like, it's just an example. I just wanted you to see something like that. That doesn't necessarily have to be the one.
And we suggest these currently to landlords, correct? Yeah. And here the standard of proof is proof of violation by the preponderance of the evidence. That's different than the burden of proof that would be required in court for conviction, which would be like beyond a reasonable doubt, right? And how much of a gap is there between preponderance of the evidence and them actually being convicted?
That's actually a great question. Beyond a reasonable doubt is the standard for criminal conviction, and it's not applicable here. And in none of our ordinance violations for anything, whether it be weeds or dog running at large, are we obliged to adhere to the beyond the reasonable doubt, because we are not seeking to incarcerate anybody if they are convicted of violating. We only have to prove by a preponderance of the evidence, and that in simple terms means that it is more likely than not that it occurred. So in terms of the scale and the evidence being put on both sides of the scale, it has to be 50% plus some is our burden of proof. And so that's not just for this ordinance, that's for all of our ordinance violations when we go to city court.
Okay, thanks. That's my questions. Thank you.
Others? Okay, I had one, and you may have just actually touched on the answer. In the ordinance that you've written in section 2. Well, under B, violations, there in the second paragraph. Near the end, it says, the last sentence reads, in determining whether any person or person in charge implemented reasonable and warranted measures, the trier of fact shall consider at least the following, and then he goes on to other parts of the manuscript. So I'm asking, who is this trier of fact?
That would be the judge
The judge of what?
in the city court.
City court. So,
And I left that blank because, again, I took this language from another ordinance that I had drafted for another city, and there was a laundry list of things that were considered, and if you saw that Aurora ordinance, you'll see it in its entirety, and so you can go and fill that in. But I left that blank because there are a number of things that we may want to negotiate. I don't want to say negotiate, but think about in terms of what we want considered. You know, it could be, if we want the judge to consider certain things in determining what was reasonable, it could be, you know, how many people were living there, who's on the lease, who's in charge, were the efforts effective at least for a period of time. You know, it's subject to a lot of discussion. I could put what I think is good language in there, and I think the language that's in the Aurora ordinance is good language. It's from a model ordinance, but that's why that's blank. And the trier of fact is, when anybody refers to a trier of fact, they're always referring to the deciding body, so that'd be the judge in a courtroom.
so it would not be an individual officer, or there's not a board at the police department?
No, the trier of fact would either be the judge or the jury,
Okay.
and most people are not going to have a jury in an ordinance violation case.
And so the landlord has been brought to court?
Yes.
Okay. I have another question for you.
Yes, sir.
Farther down on that page, let's see, 1, 2, we go past 2 in parentheses, 3 in parentheses, then we have A, B, C, D, E, F. Any other factor deemed relevant by the trier of fact, evident of a property's general reputation and/or the reputation of the persons in it or frequenting it shall be admissible.
Yeah, I knew that would catch your attention.
So you're saying that just general reputation the property has may be reason enough to consider the property a nuisance?
No, it may be one of the factors that
One of the factors.
that may be considered. What that means is you could take a rowdy bar. You know, maybe it's, and I'm not saying we have this, I'm using it as an example. It's a biker bar. And by the way, I ride a bike, so motorcycle, so I'm not impugning the reputation of biker bars. But let's say it's a biker bar that's known to be frequented by drug sellers and drug users. And the police have reported this, they've investigated it, they've been around it, they've gone out for calls for services. Everybody who, you know, wants to not bleed does not go to this particular biker bar. One of the things that the judge can consider is the general reputation of that bar in the community, as reported by, obviously, the legal staff and the police department. If the police come by and say, look, this has been going on for 3 years, this bar is a known drug haven. We get called there every night. There are fights. It's a violent place. They have poor security, on and on and on. That's what they mean by the persons in it or frequenting it and the general reputation, much like that hotel that I just previously mentioned, if it was described accurately to me.
Would this include a very active fraternity house?
No, not unless they're doing some, whatever, you know, activities on this.
Mob action?
Well, let's take, for example, if you have a fraternity, its reputation is not based on, a fraternity house, its reputation, as far as this ordinance is concerned, would not be based on the fact that it's a fraternity. Its reputation would be based on the type of behavior that is going on there. So, for example, I seem to recall recently in the news that some fraternity somewhere, practically all of the residential members of that fraternity house were arrested because they were conducting major drug sales within the house. They'd have parties, and that was the place to go. If there is, frequent fighting outside, throwing bottles, alcohol, gambling, prostitution, all these things have been known at one time or another to take place at certain fraternity houses. That is what would be the basis for determining its general reputation and frequenting, not the fact that it is a fraternity house. We couldn't have a university town here and not have fraternity houses. I mean, it's just part and parcel of college town.
I'm just trying to get a sense of the breadth of this
Sure.
wording. And I have one other question, too, and it had to do with the owning, or I guess it's the owning. I can't specifically find this in the ordinance, but it refers to illegal gambling and owning of gambling devices.
Where are you looking at now?
These are some of the other problems in the criminal nuisance property,
Okay.
or under criminal nuisances. Just talked about 17 was unlawful possession of gambling devices.
Mm-hmm.
So is this something beyond cards and dice?
Yes, this is from time to time, there are usually bars that may or may not have, slot machines, electronic roulette, gambling devices that are not allowed by law, and people are coming to that particular establishment for the purpose of gambling.
Okay, so these are more professional and
Yeah, they're just
technologically.
Yeah, I mean, it doesn't have
Sophisticated
to be very
devices.
sophisticated. I mean, some bar owners will just buy a slot machine and stick it up on the bar, believe it or not, and have no compunction about allowing patrons to come in and try to win money at it. That's illegal.
Those are my questions, and I think I'm going to, Charlie, do you have one?
Yeah, I have a couple.
And then I'll give the public a chance to comment.
I guess there are a couple of things in here. The fraternity situation comes to mind. This is a college community. We have a lot of big apartment complexes. Public indecency. I can see a couple incidents of public indecency in a large campus parking lot type situation occurring within within a 6-month period.
That
You
public
got it in
indecency,
here,
public indecency is not college kids streaking through the campus. That's not
Well,
what I'm talking about. Public indecency would be, for example, if you have a prostitute taking a john in a back alley behind a house, or at least in the area that some of the suburbs I'm from, some of the suburbs have.
Okay, let me give you a better example then.
Okay.
Suppose we have a couple of fights, assault charges or battery charges are filed. It's a big apartment complex, 2 different ends of the apartment building. You can pick one apartment complex and charge them with this and not charge them in another. I have a problem with potential arbitrariness of this ordinance. So let me, so where in the ordinance does it say it's the method of last resort? It doesn't show what, to me, if you're going to do something like this, I need to know, I need to see that the steps, what steps are going to occur first as part of the, that are included in the ordinance, so that we know when it's going to actually be enforced. Where are those intermediate steps? And then in the same way, if we have state laws that already exist, why do we need to come up with something separate? So those are 2 separate questions there.
Okay, let me go with the first one first. I'm trying to find the best way to put this. In any municipality that is trying to police this type of activity, there's a certain amount of discretion that is going to be given its staff. We don't codify discretion in any of our other ordinances. And we have other ordinances for, as you just passed, cannabis, nuisance parties. We codify battery as an ordinance violation. There are quite a few crimes that could, if it was taken to a state court, result in you being incarcerated or jailed for a period of time. But we've chosen to make it an ordinance because we want to give our city staff, our employees who are charged with, maintaining the peace, a certain level of discretion. So we don't put, well, this ordinance is to be used as a last resort in this situation, but you can really go after them in that situation. It isn't in the ordinance to make it plain. It was in the previous one because there was a longer procedure that was laid out because the city of Aurora had a hearing officer. So unlike a court of law, which already has its rules of procedure, I had to lay out a system or a procedure for that city to be able to bring cases before a contracted hearing officer and how that was going to go down. In this particular situation, the best answer that I can give you is that it's not codified. But one thing I can tell you is the reality of the situation is if I were able to, if I said to the chief of police, Chief, could you please go and have the statistician run all of the properties, as I did in Aurora, that have 2 or more violations within a 6-month period of time. I had a stack of printouts like that, like this thick. Do you have something there? That's my follow-up. Okay, so you get a stack of property that are literally, the printout was about this thick, and there were like 40,000 households and 170-something thousand people in that city. Realistically, we are not going to scorch the earth with this ordinance. We don't have the staff or the time, and I don't anticipate this city ever having the staff or the time to go after it. For example, let's say there's a household where there have been 2 calls for some sort of domestic dispute. And in one instance, one spouse hits the other, and in the next instance, the opposite spouse hits the other one, or, one hits the kid. That is not the type of property that is posing a nuisance for a community. Hardly anyone is going to complain because a couple of times in a 6-month period of time, the police showed up at their neighbor's house because of arguing and fighting. Nuisance activity, the type that would get this attention from this ordinance, is the type that of issues that I put down here. It's the type of activity that is on an ongoing basis, and it has a severe deleterious effect on the quality of life in a neighborhood. So I don't really think that there is a reasonable example that anyone could come up with where we would need to codify the fact that this is the nuclear option here. There may be some instances where it is the last resort, but if it's, for example, the unlawful use of weapons or firearms, or the unlawful discharge of a firearm, we may have to go after that property fairly quickly. It may not be a last resort. We may say that, property owner, the tenants in apartment, 21B and 21C have been spotted firing off weapons. And, the residents know who it is. They may have been arrested, maybe they haven't yet, but you need to be aware of this, and we expect that you will do something about this tenant.
Ron, I guess for me, if you can describe these situations, then some aspect of that needs to be included in the ordinance.
Some aspect
some
of what?
aspect of your description of how it applies in these sorts of situations, but not in these others.
I would rather that you not pass the ordinance then, because there's no way to come up with enough examples or to come up with enough descriptive language that would do anything but frustrate the police in the city. It would be better. It's better to have no ordinance than to have one that tries to do all of that and fails at it. And it is my legal opinion that we cannot come up with that kind of language.
Okay. Well, then something that would be very helpful. And my last question, the thing I was going to request was the numbers. What do we have? where would it have applied? If we go back and do the stats for the last, X number of years, whatever's available.
Sure.
How many cases would actually have come up that just fit the criteria? And then when would such an ordinance as this be applied in those situations?
I will definitely check with our local constabulary, but if they are able to run those numbers, I don't know.
And Chief, we
if
can
they
talk about it later unless you have it now.
And Chief Billy, do you want to make comments generally about this ordinance? And what
I
it
think
affect us?
Ron described doing that in Aurora. So, that's the kind of thing I'd like to see. What he did in Aurora.
which is print out properties and how many properties would qualify under this ordinance. And we were able to do that because we had a full-time statistician and there was the software and they kept that kind of stuff so they could print reports. I would be happy to try to work with the chief to get that information, but I don't know that he has it broken out that way.
Maybe even some examples would be adequate, rather than a whole spending hours.
Okay. So Chief Bealey, do you want to address that?
As far as the statistics you're asking for, I think it would be fairly difficult to come up with those things. I personally, just off the top of my head, don't have anything in mind for this ordinance. I don't think we would use it very often at all. In talking with the city attorney as this was being proposed, and I do want to point out this is not a product of the police department wanting this ordinance. This came out of the Neighborhood Safety Task Force. The police are also figuring out how we would use this, in what methods, where would it be applied. The city attorney and I are in agreement this would not be police officers on the street, just as they give out speeding tickets to people, handing out this ordinance violation. It would be in those rare cases where information was brought forth that warranted the extra review, if you will, of high-level police department staff in consultation with the city attorney and maybe community development in a more holistic approach to solving a major issue. I think trying to look back all the things that this could apply to, we could spend a lot of time and come up with 1,000 times it might apply over the past 10 years, but we would never have used it for any of those 1,000 times. So I'd be happy to work with you to come up with things, but I hate to spend a lot of time trying to look in the past if it never would have been used in the past.
This makes me wonder then, if you can't come up with, if you have no examples, then, Lynn has suggested we need to come up with some examples. If we don't have any examples, then we don't need this. So,
Can I-
let me finish. Okay, and yet, Ron did point out a very good example for a hotel property that was a real nuisance a number of years ago.
Going back a number of years.
And I can remember a mobile home park that was a major nuisance 15, 20 years ago. Again, major, half the calls for the city police department were to one mobile home park in the city,
Long time ago.
Yeah, a long time ago. So I can see examples. Okay, but if we can describe these major incidents, then it strikes me that we can figure out a way to include that kind of parameterization on this ordinance so that it doesn't appear to be something that is so arbitrary.
Let me address what you were saying before about us not needing the ordinance. I drafted this without passion or prejudice, so it doesn't matter. You all will have to decide if this is what the city needs. But I do want to address what I think I understood Chief Bealey to say was not that we couldn't come up with examples, but saying that we could come up with 1,000 examples that qualify under this ordinance where we could have, so to speak, pulled the trigger and used this ordinance to violate them. But we probably wouldn't for all 1,000 of those. So it's meaningless to say, here's 1,000 examples of where we could have done it, when probably they aren't the real examples we would have used. The examples we would use, I can name probably right now 2 or 3 complexes and at least a couple bars and some properties that may be in areas that are, where annexation is imminent or will be coming soon, that Again, in the interest of discretion, I don't like sitting here naming out these particular properties.
But you see, we've got, but then, see, there's some parameters in your head about when this applies, okay, that make it less than arbitrary.
But they're
And that's-
divergent. The examples are so divergent,
well,
I can't put parameters on it.
I would ask you to give it a try, give it some thought, give it a try.
Okay. Maybe at this point, if there's not any more questions for either Chief Bewley or Attorney O'Neill, let's have our public input on these topics. There's two people who wanted to speak at the time concerning criminal nuisance, Diana Visick being the first. And then please give us your address and your name, and you have 5 minutes, Diana.
I'm Diana Visick, and I live at 608 West Pennsylvania Avenue in Urbana. Although I've spoken to you about this issue before, I've been thinking about it and have more to suggest. It seems to me that this ordinance originates in the frustration we all feel about the inability of the legal system to deal with repeat offenders. In fact, Ron O'Neill's example of the crack house is a perfect example of this, where the legal system has not been able to stop the dealing or stop the using. Cities have decided to take matters into their own hands by imposing penalties on property owners, which in our case would be fines of $300 to $750 a day. Because the fines are so onerous, this ordinance would have to be selectively enforced. If the property owner is the perpetrator, then we're imposing penalties much more harsh than the statutes provide for that particular crime. That isn't fair. If the property owner isn't the person committing the crime, then we're punishing the wrong person, which also isn't fair. In order to mitigate the fines, the property owner would be expected to evict the problem tenant. But as long as that individual is alive, he has to live somewhere, and there are only a few choices. He can become homeless, thus adding to a difficult problem we haven't figured out how to solve. He can wind up in jail, which all of us pay for. Or he can move somewhere else and inflict his bad behavior on some other neighborhood. Eviction doesn't solve anything for the community, although it may make life easier for the landlord. And in Ron's example of the crack dealer, just because he's evicted from a particular residence doesn't mean he's going to stop dealing. A crack user is not going to stop using. The dealer will just start dealing out of his car, out of a local park, or out of some other location. It doesn't stop the behavior. If we wish to actually eliminate bad behavior, then we have to be more creative in our punishment strategies. Last time I mentioned the success that restorative justice is having in other communities as well as our own. On Thursday, February 12th, the Champaign County Libertarian Party will be hosting Sally Wolf, head of the Illinois Balanced and Restorative Justice Initiative, who will talk about alternative approaches to reforming offenders. This meeting will be at 7 p.m. in the auditorium of the Urbana Free Library and is open to the public. Ms. Wolf may be able to help us identify better ways of dealing with nuisance properties than this ordinance provides. In regards to selective enforcement, it's important to realize that oppression generally doesn't come out of a desire to be evil. Most noxious governmental actions come from a desire to maintain community standards, ensure safety, and, quote, do the right thing. If we want to have equal protection under the law, then we need to avoid selective enforcement and other forms of subjectivity. If we don't want an ordinance applied to us or our friends, then we shouldn't pass it. Although the current administration in Urbana might use this ordinance responsibly, there's no guarantee that wisdom would continue. This is especially scary because Ron O'Neill was talking about using the preponderance of evidence as the standard. And while it is true that violation of this ordinance might not result in incarceration, it could certainly result in bankruptcy and other forms of great suffering. It's also a problem because he says we can't codify discretion. This means it's really arbitrary. And as he says, it's better to have no ordinance than to have to codify it. If that's true, what we're really looking for is huge powers of discretion, of subjectivity, of unequal protection under the law. And really, if we can't come up with examples at the moment where we need something this powerful, I think we should just leave it alone. Rather than creating problems for the future, let's solve the issue at its source by exploring more effective means of reducing repeat criminal behavior. Thanks.
Okay, back to Diana. We also have another individual who wanted to speak on this issue, and that would be Durrell Cruz.
Hello, my name is Durrell Cruz, and I live at 2007 South George Huff. We all support reducing criminal nuisance behavior, but this ordinance has some sinister aspects to it. It is narrowly focused, twists the concept of personal responsibility and culpability, and overly relies on a punitive approach as a solution. It contains serious wording flaws that could easily lead to unintended, unfair, and unjust consequences. And finally, it fails to respond to the human issues and needs associated with criminal behavior. It seems the city is simply seeking a quick and politically appealing solution to a difficult problem. When it comes to criminal or delinquent conduct, isn't the principle clear and simple? If the property of a landlord violates city building codes, the landlord should be fined. If a tenant behavior violates the law, the tenant should be charged. This ordinance reverses this relationship and makes the landlord responsible for the behavior of the occupants. Consider for a moment Meadowbrook Park. Police are called for vandalism, property damage, drug dealing, and other types of criminal behavior. Following the logic of this ordinance, the Park District would be responsible, or at least acquiescent, is the word that's used frequently, for the criminal behavior of park users. Should the city therefore declare the park a criminal nuisance park and fine the Park District until they put up lighting around the walking paths, security cameras in the parking lot, or hire a security person on the weekends? Major shortcomings of this ordinance, and many of them have been stated already, is the selective and arbitrary way a property is declared a nuisance. The fact that the police chief alone gets to define the corrective warranted measures, section B2C. 3, the potential of innocent adults and children being evicted from their apartment, not for wrongdoing, but rather by guilt of association, section B5C. The lack of recourse or due process for the property owner or the affected individuals. And finally, the potential abuse of unlawful and discriminatory leasing practices, denying certain populations their civil rights to fair and adequate housing because of the existence of this ordinance. Some believe that the physical condition of property contributes to increased criminal behavior. This may seem reasonable on first glance, but it is far from proven. Several years ago, I attended a religious workers meeting on the U of I campus to discuss 3 major problems facing students. They were as follows. Number 1 problem, you probably can guess, substance abuse, underage drinking, binge drinking, use of illicit drugs was number 1. Number 2, surprisingly, was gambling, poker, electronic gaming, students literally losing thousands of dollars to illegal gambling. Number 2 problem. Third one, sexual abuse, assault, and relationships problems between couples. The minister of the Twin City Bible Church described how many of these students lived in or near the sororities and fraternities. Sounds like some familiar criminal nuisance behavior concentrated in some pretty nice buildings. So we need to be careful about the association of building condition and criminal behavior. More importantly, however, was the university's response to these problems. First, there was a clear message of the consequences of engaging in criminal behavior from a student being placed on probation, being expelled from the university, to being prosecuted in the criminal justice system. But the university's response did not stop there. They also put in place educational, social, mental health services to provide the support and assistance to the students dealing with these issues. In fact, the university's goal was first to help and punish second. Why was the university willing to do this for these adults? On the other hand, the city's response in this ordinance seems overly draconian and punitive. Is there a tinge of race and or class bias being reflected in the wording of section B3A? A property's general reputation, the reputation of a person, the people frequenting it? What exactly does that mean? Next year, the city of Urbana is budgeting over $8 million to the police department for law enforcement, yet only slightly over $200,000 for social services. Certainly, the city recognizes in today's world, hundreds of its citizens are under immense stress emotionally, mentally, and financially to provide for their basic needs. As the city literally pumps millions in time and money into programs such as economic development, tree preservation, bike paths, recycling, public art, street beautification, historical preservation, public television, library services, one must ask the simple question, why is there so little help offered to direct needs of citizens? Maybe to solve this problem, a change of focus is necessary. With the readjustment of the social services budget and a bit of creative and aggressive grant writing, the city could create the position of a social services offender reentry coordinator, for example. Let me give you some examples. It was mentioned a little bit earlier, the landlord training program. What if the city developed through this position informational and educational materials to be handed out to tenants when they sign leases? What are the tenants' rights and landlords' rights and responsibilities? How do I deal with disruptive neighbors? How and when do I report problems to my landlord? Report them to the police, report them to the city. Somebody talked about the problem, we have felons coming back to our community. One of the most aggressive programs being researched or worked on by cities is the offender reentry program. President Bush and Congress has passed the Second Chance Act. It simply provides funding for communities who apply for it to identify an offender reentry coordinator who meets with people coming back into the community to make sure they have the support and means to reintegrate successfully to avoid the problems that they might have. Imagine if the city had a social services referral center that would direct individuals to existing community organizations and agencies that relate to a person's particular situation or needs, such as health care, job training, drug treatment, food and clothing assistance, child care, etc. And lastly, and Diane mentioned it, I just came from the Brookins Center, and I attended the second meeting of the Teen Peer Court. It's a restorative justice program for juveniles. It's a way of dealing with criminal activity that occurs in a restorative way that makes people responsible for what they've done and to restore what was wrong to the victim. So we must recognize more than ever now that some people need help and support, especially if they are willing to accept responsibility for the behavior, willing to take advantage of help when offered, and willing to improve their life situation. For a small investment, the city could provide assistance to its citizens. Isn't it more preferable response than just kicking people into the street because the property they live in has been declared a criminal nuisance property? And I would close by simply saying that Urbana is not Aurora. There are differences, significant differences in the makeup of the community between Urbana and Aurora. Thank you.
Okay, any questions for Darrell? Thank you, Darrell.
Okay.
Okay, that's public input. We've had a presentation by staff. Okay, Councilman, well, let's start with Lynn Brands.
Thanks, Dennis. Yeah, I think, I'm glad you brought that up. This also erupted out of the Neighborhood Safety Task Force, actually now, a number of years ago. And I'm quite pleased that we're discussing this and that hopefully we can implement something. It's probably not soup yet. You know, there's things that we maybe need to tweak about it, but I certainly hope that we can implement what I see is simply a tool. true, okay, we're not Aurora, but I would say, and this is true, in the past 4 years that I've been involved with the council, this is the most common theme of concern that I heard from my constituents. And Urbana has a very high number of apartment dwellings and a fairly significant number of where we've had some major concerns. And I think they've been well documented and in our prior conversations sometimes. And really, I think really what caused us to consider having public safety be, I think, either our number 1 or number 2 goal. It's our number 1 goal with economic development right behind. And economic development, of course, is the safety of communities is key to economic development. When people don't feel safe, they don't want to live here, and businesses don't want to locate. And certainly we don't have rampant problems throughout the community, but we have some hot spots and have had for a number of years. And I think any tools that we can give to help to mitigate those problems, our constituents, the neighbors of those dwellings where things like this can occur, whether they be apartment buildings, homes, or businesses, are well served by careful use of tools. And I think to Charlie's point, to speak about, to try to put more boxes and parameters around this, I think, if we have issues with the way our staff carries out various policies, then we need to deal with our staff. It's very difficult to direct in a written document every detail of a person's job around a particular subject. And so I think that will be a difficult thing to do, and I hope that we don't turn away from this simply because we cannot prescribe exact actions. So I'm supportive of this.
Thanks very much, Lynn. Others? David? We can hear you, but you need to speak very close to the mic.
Okay. There are a couple of things that I think that I really need in order to support this. Some of the sample or the other ordinances that you provided us with included a full a section that actually laid out the procedures so that you'd have this roadmap of A happens, then B, and so forth. And I think spelling that out, it would, again, it would allow for the exercise of discretion, because you could say that this actor at this point will, by their discretion, will do such and such. I think spelling that out would be useful. It would be useful for the property owners because they can see exactly that this is how the dance goes. I think that it would also be a very helpful way for just to address some of the community concerns about how this is actually going to be played out. Since it's the intention, I understand that it's not possible effectively to say to codify what your motivations are and say that I'm only going to go to step Q under dire straits. But I think that laying out the line, one thing that I would like to see is before there's any attempt to prosecute under this, it's supposed to be a very rare thing. I'd like advance notice to the City Council. Maybe it doesn't have to be formal. I mean, in terms of actual presentation in one of the meetings, but I'd like to see some advance alert to us. Theoretically, that's going to be very close to when you get to the Armageddon clauses of the whole procedure. So I don't think it's a time constraint necessarily, because certainly a lot of time will already have been spent in various forms of negotiations and so forth before that. I think adding the additional step of council notice, and again, it doesn't have to be a super formalized thing, but some way of letting us know. That will also let us have a sense of how this is actually being used in the field.
Just a clarification, you want notice even if we're just seeking fines or for any prosecution, or if we were to go to the nuclear option.
I think if we're talking about actually closing a unit or a block, I think at that point, only when we get to the direst of the dire straits. But that'll give us a chance to see and judge how it's being used, and I think that could help make the case a lot better than going through hypotheticals for the last 10 years of the record. The other thing is, and this is something that I'm just suggesting to see what the council has to think about it, is the possibility of including a sunset clause. That if we're uncertain about how this will be used on the street, then maybe it makes sense to give it a trial run and see if it does what it's supposed to do, and if it's if it meets the needs, then we'll know, and it'll be no problem to extend it beyond that. So that's my comments.
Mayor Pressing?
Well, I was going to suggest along those lines that we could always put in an evaluation after a year and a half, which we've done with other ordinances, because we get feedback, and if we have to change something, we'll change it. And of course, if something comes up earlier, we can change it too. But it's good to have a formal analysis of how it's proceeded.
Okay. Brandon?
Yeah, Ron, thanks. Thanks for answers and for leading more discussion of this. I, at this point, don't support it, but want to provide maybe 4 different suggestions of ways that it could be changed such that I could support it if a majority of folks are interested in continuing to work on this. First, the condemnation of whole buildings and the sort of emptying of an apartment is, I know, the last resort, but something that I don't support in as broad a way as it is here. And like you said, we never really get to that. Well, if we never really get to that, if it is just a threat, then let's not include it in the ordinance. So I have even 4 different ideas for how to not include this in the ordinance. One is to just plain take it out and stick with fines. That, you know, obviously a fine of $750 a day for a landlord is really significant, and we don't have to close the building, but by imposing a fine, and put people out on the street, but by imposing a fine, they would still be motivated to work with the city. Second, instead of just emptying out a building, closing it on a set day, we could provide for maybe the inability for the landlord to renew leases or to sign new leases, so that as leases expired, the landlord wouldn't be allowed to renew them or to sign new tenants on, but we wouldn't just empty the building out on the day that we found that it was in violation. Another idea is to just close one unit at a time, which you said was one level that you had used in Aurora, but not even allow closing the whole building. And if there's a problem in 2 units, we could prove that there was the criminal activity twice in each unit and close 2 units. And finally, maybe to set a different threshold for closing the whole building, if that would be an option that people wanted to leave in, but say that if you were going to close a whole building, it could only be because of 8 or more units where there were occurrences, or 30% of the units that had criminal behavior proven in some amount of time. Some higher threshold. I really am not supportive of the idea of just closing the whole building tomorrow, putting people out on the street. So that's some ideas for how to accomplish that first suggestion of not closing the whole building. The second suggestion is to narrow the list of some of the violations that count towards your 2. Obviously, dealing drugs or prostitution, those are serious things that if they happen repeatedly in any building or an apartment unit, that's a problem and is a problem for the neighborhood. But some of them on the list maybe we could take off because they're not the things that I'm thinking are the reasons we need this ordinance. Things like obscenity, public indecency, pandering, and I'll put these ideas in writing too so that you don't have to try to jot each of these down. But those are 3 things that to me aren't the reasons that motivated this ordinance. They aren't why the Neighborhood Safety Task Force wanted this. We have other ways of dealing with those problems if they come up, and they're serious problems, but they're not the reasons we would want a new tool to shut down an apartment building. Whereas drugs, prostitution, those are the things, to me, that are so severe that we would want the ability to close a unit or close a building. Third is the issue of education. I think if we enact this, it's really important to have education to the apartment owners on basically the law that they cannot discriminate, because I would fear that apartment building owners would decide to discriminate more based on race or something because they have some prejudice and decide that, well, if they're going to be fined for any criminal behavior, then they might decide to discriminate based on race or other reasons that are not allowed by our ordinance. So I think education on that would be very important, and also education on how they can evict a tenant when there is actual criminal behavior at the time. And fourth, my last suggestion would be to clarify the scope in this ordinance of the things a landlord would be required to do, the things that the police chief would be allowed to ask the landlord to require the landlord to do, and make a list of those things. And again, I'll put this in writing, so you don't have to jot these all down. But if we could say that what the police chief was allowed to require would be, inserting a lease addendum into future leases, or holding a meeting with police, or installing lighting per some security plan, or having a 24-hour doorman. Those are specific things. I don't know if we want to say that we'd be allowed to require those or not, but giving a particular list so that all the people who own property in this town would know what the possible things we might be imposing would be, or at least categories of them, rather than the vague, well, you've got to do whatever the chief says, and that could be anything. So those are four.
I have to clarify something, because that comment got made again that the chief is going to declare what the landlord is going to do.
Okay, yeah. Go ahead.
And I just want to clarify something. It's fine, we can do what you're suggesting, but the chief does not tell a landlord, you must do these things. And so I'm a little concerned about clarifying the scope by putting in quotation marks of required actions. Mm-hmm. Basically, what the chief does is say, look, you've got a nuisance property here, and you need to take some reasonable steps to do that. The landlord can do any number of lawful things, but none of them can we cannot force a landlord to do something with their property specifically. We can only tell them to abate a nuisance. So what this language involves is you coming and saying, look, here's what I intend to do to abate that. It may not be on a list that I have come up with, but it may be something that the city says, yeah, that's reasonable. As long as you're trying to do that, we can accept that as an initial step. And I'm going to offer this one small addendum to what you said about the education. I mean, education never harms anyone, but I bet you almost all landlords know exactly what they can and cannot do lawfully. I mean, you're dealing with HUD, you're dealing with the state, you're dealing with our own ordinance. I mean, any landlord that has any questions at all is always free to, and one of the things that we emphasized even in our landlord training class is that, at least I advise that every landlord should become familiar with that. And so we definitely can create a packet, and that's part of it was the addendum language that for drug-free housing that I handed out. It's like something they say, here's something you can put in your lease that would assist you should you have these type of violations. Be happy to do all of that. I don't know that I would codify that, so I just want to throw that out there.
Yeah, I appreciate the feedback. I do think that education is important so that we're providing information so that landlords, even the few that aren't aware, don't have any reason or excuse to discriminate, that they clearly know the law. And I also appreciate your comment about the specific measures that the police, the city could give a list of specific recommendations, but in the end, all that they would be required to do is abate the nuisance, and we couldn't say that that's the exact 7 things. So
sure.
I appreciate that. So those are my 4 suggestions. I do also like some of the ideas that Charlie and David have put out there about a sunset, or taking out the whole reputation piece, or saying what specific steps we take before it gets to the closing the building option. or Charlie's suggestion of how to put parameters on it. I support all of those things too. I'll put my 4 in writing just so you have have those notes written down and we could meet or follow up phone conversation, any of those things. So I guess in summary, I don't support this yet. I do understand there's a problem with really uncooperative landlords who even hinder police work, who actively allow and encourage criminal behavior on their property, and we do need a tool for that. But this tool right now seems more broad than I'd support. So some of these suggestions about how to tailor it and make it the right tool for that job are things that I think would go a long way. So thanks.
I also wanted to add that one of the leading proponents of this type of thing is Schaumburg, which is a much smaller community than Aurora. It's closer, not exactly, but it's closer in size to a Champaign-Urbana area, and they are one of the, they were one of the benchmark setters in criminal nuisance and crime-free multi-housing.
Okay. All right, and even I have a comment, but okay, Heather, do you want to make a comment, please?
Well, now that we're into this discussion over an hour, I'll keep my remarks as short as I can. I know that there's been a lot of work that's been put into this. There's some good arguments for, some really good arguments against this ordinance, and what I'm hearing from my constituents is that this is just one more form of nanny government, and I've heard this from several of my constituents that we've got things on the books already. The human rights ordinance really prevents landlords from being able to prevent having these kind of people in their properties to begin with. The state, the state already has things on the books. I think this is just one more thing that is really unnecessary, and like I said, it's just the government and Big Daddy breathing down our necks, and it's unnecessary, and that's what I'm hearing from my constituents. So I will not be voting for this.
Okay, Robert Lewis.
Well, as I look at this situation, I look at it a little differently in some ways, in that I've seen in this community, our community, situations that continually to cause problems in communities, especially with drug problems and cocaine, selling it on the street. I've seen it all. Prostitution, you name it, I've seen it. Maybe in your part of the neighborhood it didn't happen, but I grew up with it. It's here, it's present. And I think this kind of ordinance, even though some people might think it's a little heavy-handed, but on the other hand, where I come from, it takes a heavy hand sometimes. And I don't think it's that heavy-handed. I think it's very light. I would like to, if you could fax me or email me the state statutes. I'm familiar somewhat with the federal. So the state correlation, I'd appreciate it, and I can review it for myself.
Okay, other discussion? I just had one thought. I know that we're talking about, criminal activity, and what is it that takes that, maybe I was looking at the level of repeated actions, and I'm kind of just going to ask this question. If an instance happens in a house or an apartment once, well, that's an incident. Now, if it happens again, does that automatically mean that that property is a criminal property? To me, it seems like the threshold of 2 instances in 6 months is very low. And I'm wondering if, since we're talking later on in the ordinance, that we're talking about properties that may have reputations for criminal activity, that to defer or winnow out certain kinds of events from continual focused property violation locations, maybe the barrier should be 3 to 4 instances in a 6-month period would then classify a property to receive the blunt of this ordinance, which is basically your heaviest hammer. Now, I don't know if you indicated yourself that in Aurora you had a stack a half an inch high of properties they had 2 incidences. But if you're only going after those properties that have serious repeat performance, why don't we just say, 4 or 5 instances in 6 months? Definitely, you're on the books for that. No getting around it. So why were we even talking about 2? That's just my comment.
Did you want me to answer that?
You could perhaps address that.
Because it depends on the neighborhood, it depends on the property, and it depends on the activity. We might have some rural area where a couple of calls for gunshots fired. It's no big deal, you're out in the country, okay? We could also have a gas station or a bar or a apartment complex where 2 incidents of gunshots going off is extraordinary and has the entire complex neighborhood terrified. Let's move away from violence and talk about, for example, prostitution. It's hard for me to even imagine what it's like because I've never lived anywhere where I had prostitutes walking in front of my home, but in other contexts I've spoken to people who have. And so, we think, well, it's sort of a victimless crime. Well, it isn't if you live in a neighborhood and you have prostitutes plying their trade around your home and you have cars coming up and down the street, at 2 or 3 in the morning. Or if you live in an apartment where the person next to you is plying that trade. So the reason that we put 2 is for a few reasons. One, because in my research that seemed to be the common number that was used. So I'm going to be honest with you, it was really not so much specific to Urbana in that sense. It was the number that I saw in the model language, and it's the number that I saw other communities using. And when I got to thinking about the different activities, I actually went down the list mentally and said, okay, if there were 2 incidents of this from my neighbor's home, how would I feel? Well, and then I went to the next one and the next one. So some of them, you might say, well, 2 incidents of indecent exposure, a couple college kids mooning each other. That probably would not do it, make me that upset. But 2 incidents of, a prostitute, having intercourse in a car, parked near my home might. I have 2 children. So it just depends. And that's really the bottom line with that number. I certainly have no problem raising it, but you need to understand that raising that number could have an unintended effect of now raising the threshold to stop behavior that needed to be stopped with incident number 1 or 2. So just want to throw that out at you. And then the question becomes, which one of these could you live with more than 2 times? Which one of this type of activity could you live with if it happened more than twice in your neighborhood?
Okay, thank you. Is there a motion for activity, either to forward this or to retain this in committee? Or is this going to be merely an advisory? This is an ordinance. Do we want to move it someplace? Okay, Lynn Barnes.
I think it needs further work, so I don't think it's at all ready to go to committee, but I'd like to see it come back to, or go to council, but I'd like to see it come back to committee at the next opportunity.
Okay.
Or possibly even maybe it should be in January, because we only have 2 more meetings left. 1 more meeting. That's right, the 8th. We only have the 15th left. So we probably should just ask to see this back in January, another draft based on a lot of the comments and input.
I want to clarify, I'm more than willing to bring that draft back at any time with the amendments, but I need some clarification because there were a lot of different suggestions. Some of them are redundant, some of them are at opposite to each other. So I guess I would would request that there be some, perhaps maybe a clarifying motion that says, you know, we want to see a draft with these particular incidents. I don't know if the chair would like to sum up, or do you understand what I'm getting at?
Right. There are a lot of divergent thoughts about what this might end up being, so I'm not sure we're ready to draft on the floor what the corrections could be at this point. Laurel Pressing.
I have a suggestion that everybody write up what their comments are and get them out to everybody so we can sift through them. Then we'll know, we'll have some wording to
Include
talk
Ron.
about.
To Ron and others.
To Ron and to all of us so we can see them.
Okay, well, that seems
A
reasonable.
list of proposed changes and who it is so we can talk to them about it.
Okay.
If you would like to email your written suggestions, I know, Brandon, you indicated you would do that to me. If any, I could compile them maybe in one Word document and then email it back out to all of you for you to consider and maybe decide, you know, at the next committee meeting that, hey, these are the things, these are the real changes we'd like to see. And, you know, if I have time to do it before the next meeting, I might just fiddle with it myself, just to try to incorporate some of the ideas that you're talking about and see if I can come up with draft number 2. Just in case you're interested, in the city of Aurora, we went through 9 drafts. So I'm hoping that we don't have to go that far, so that's why I'm doing this a little differently this time. But, so, yeah, I can do that.
Okay, so a second draft would not be out of order for sure.
No.
David.
I just wanted to say, if there are cases where we've given you one thing in one year and the opposite in the other year, it might be worth drafting alternate language and marking it as such.
Okay, so really we're going to want to compile an addendum of possible changes to the ordinance as given, and hopefully Ron will collect that information, and so therefore this will return to us then in January at the first city council meeting in not council, but the committee of the whole meeting in January. Yeah, we probably do.
Yeah,
Usually we make the motions a little more open-ended, like when it's ready.
yeah, that's fine.
All right, when it's ready. Okay, then I'll make that motion that this document receive committee input, and we'll see a second draft with potential addended material return to this committee sometime in January or when ready.
Second.
I just want to say one last thing. I'd encourage you all, before you make your suggestions, to read through the materials that I have, because I really think it's good stuff, and it can help give a perspective maybe from some of the people who live, you know, not just from the perspective of displaced people, but also people that live in communities where this is used, and some good practices for landlords.
Okay. All right, so there's a motion. All those in favor, say aye. It's been seconded, of course, by David. I think we're ready to vote on it. Is there discussion on the motion? All right. Those in favor of having this return in January, say aye.
Aye. Aye.
Okay. Those opposed? We don't have to make a vote. It doesn't have to be a hand vote for this, does it? Okay. All right. All right. Ordinance number 2008-12-138, an ordinance vacating a public alley in the Church Street, Park Street, Lincoln Avenue, and Busey Avenue block. Bill Gray for Public Works.
Just summarizing the memo, this is the last bit of city public right-of-way that needs to be vacated to accommodate the expansion in the MIC area for Carl Foundation, and the location, as stated, is between Church and Park, Lincoln, and Busey. It's a portion of an alley. City council action some time ago had vacated a portion of this same alley to accommodate the spinal center that's been built, open and operating at the corner of Church and Lincoln, the southeast corner. So Carl owns all property now on both sides of the alley, and there's a modest payment in reflecting the appraised value. And I'll be happy to answer any questions.
And I'll recuse myself, since it's related to Carl. Thank
Okay.
you.
All right, comments. Heather Stevenson.
I'd like to move ordinance number 2008-12-138 to City Council with the recommendation for approval.
Second.
Okay, Charlie seconds it. Is there any discussion? Okay, seeing none. Those in favor of doing so, please indicate by saying aye.
Aye.
Those opposed? Okay, that moves towards City Council with approval. Okay, there's items from the Traffic Commission, from Public Works. Bill Gray, do you want to comment on any of these?
I guess if there's any questions, be happy to answer them. It's pretty straightforward. There's some stop signs that meet warrants at the selected streets per the ordinance title. We're looking at establishing permanently loading parking in Mumford and Anderson on Sundays to accommodate a church request some time ago. And lastly, with the Meyer store open at Scoville and 50 Road, it'd be important for safety and operational reasons that we prohibit parking a little bit west of 50 and Scoville.
Okay. Okay, Brandon?
I just had one question to understand the church parking at Mumford Anderson. I didn't understand why, in order to allow Sunday parking, we were putting in place a 30-minute parking pickup drop-off zone, loading zone. What's the relationship between why this is a 30-minute loading zone versus how we can allow Sunday parking?
Well, I think it's 15-minute, but, well, whatever it is. The loading zone is during school days. It's Monday through Saturdays, Monday through Friday there, I believe, or Saturday, I forget now. But this allows parking longer term on Sunday.
Shanky Ridge School.
So it's like an exception to that loading zone limitation?
Correct.
Okay.
Yes.
Okay, are there any comments or questions? Okay, Heather, you want to
I was
go ahead?
going to
Make
an
omnibus motion.
move that we send ordinance 2008-12140, 141, and 142 in omnibus fashion to the City Council with recommendation for approval.
Second.
Okay. All right. Seconded by Charlie. All right. Any comments or questions or discussion? Okay, City, maybe let's take a vote on it. All those in favor of forwarding this to City Council with approval indicate so by saying aye.
Aye.
Opposed? Okay. Omnibus fashion, those three ordinances concerning traffic go before the City Council. Item number 8 on our agenda tonight is an ordinance number 2008-12-143, an ordinance revising the annual budget ordinance. This concerns Get Out the Lead program, Phase 5. Does anyone wish to speak to it? Perhaps Libby Tyler is there.
This is just a budget amendment to accept our grant from the Illinois Department of Public Health for the Get Out the Lead program, and that's in our annual action plan, so it's already been budgeted in terms of our match.
Okay. Any discussion or questions for Libby concerning this program? Is there a motion? Okay, Brandon moves it.
Second.
Seconded by Robert Lewis. Okay, further discussion at all? Okay. Those then wishing to advance this to City Council indicate so by saying aye.
Aye.
And opposed? Okay, this advances to City Council. Okay, now a resolution authorizing the, I will read the resolution number, 2008-12-028R, a resolution authorizing the mayor to execute a certification of consistency for the Housing Authority of Champaign County 5-year plan for the years 2005 to 2009, and the annual plan for the years 2009. Presentation by Libby Tyler.
This is our annual review for this certification of consistency that HUD requests. And what we do is compare the Housing Authority's fiscal year plan, their 5-year plan with our 5-year plan, our consolidated plan, and review the just the plan portions that pertain to Urbana and to our consolidated plan. So here's a summary prepared by John Schneider and the grant staff. Of course, every year we look for consistency in the language with the Lakeside Terrace redevelopment, and we talked about that recently in our frequent updates on Lakeside Terrace and with the new Crystal View townhomes, which are now starting construction, and work closely with the Housing Authority to make sure the language of those replacement units was clarified in their consolidated plan. They did provide us recently with a letter to verify what their obligation will be to provide a minimum of at least 25 of those units for very low income replacement. That's the same exact language that you'll find in their annual plan, and so that's set forth in our staff memo, page 2, under Lakeside Terrace redevelopment. Then there's some additional provisions that talk about increasing affordable housing units overall, and here we get to our 2004 document, our Lakeside Terrace redevelopment plan, where we're looking at trying to come up with at least 80 replacement units. And in the Housing Authority's annual plan, they talk about some additional strategies that will help, and one of these is the purchase of the 6-unit apartment building. Directly behind us is the James Hayes Apartments, and that's 6 new units of public housing in Urbana. In addition, the Housing Authority is working on adding 3 additional apartments to Steer Place in southeast Urbana, so that will add to that inventory of very low-income housing in Urbana and Champaign County. Let's see, they're looking also at acquiring other properties through the multiple listings for their scattered site programs. And Ed Bland and Patty Smith are here this evening, and they can tell us more about that or their other programs. So we're really looking at replacement of just these initiatives of 34 units. And then in addition, in previous years, through the Urban League, we've added to that inventory at their Park Place and Crestwood Terrace properties. So we're getting very close to our goal of 80, which is good. Next, we talk about consistency with families with disabilities. And again, the Crystal View townhomes will meet our visitability requirements as well as state requirements for visitability and accessibility. So that's also consistent with our consolidated plan. The next section deals with Dunbar Court, and this will be an upcoming project for the Housing Authority to redevelop that public housing project in Urbana. They've done an assessment back in 2005 that shows that it would not be cost effective for them to remodel the units, and instead they're looking at a redevelopment plan for that area. And I'm sure as that plan develops further, the Housing Authority will come and update us and show us some of those plans. And the proposal would be to maintain the same level of bedrooms, but to change the unit size mix. And maybe questions about that the Housing Authority can address. They've also asked the city to work with them for possible expansion of that site. And that's something that we can look at in terms of if there's some vacant properties nearby or some abandoned properties as well, that site can be extended. So that's a new project. This is the first year where this has really been mentioned in this level of detail in their annual plan. And we have some additional points from their annual plan about improving the quality of the housing stock, implementing their Section 8 homeownership program, and again, redevelopment of Lakeside Terrace and how that relates to our consolidated plan. And then finally, we pulled out just some additional points of relevance to Urbana, that there's a proposal to designate both the Hayes Homes and Steer Place in Urbana for low-income elderly only, some updated information on their Section 8 homeownership program, some information on deconcentration and income mixing, increased tenant screening, and I think we note that there really is a very high points now, scores, if you will, from HUD for our public housing authority. It seems to be climbing, and they're rated a high performer now by HUD in their 5-year plan, and they're achieving scores of 90 and 96 on two of the criteria that HUD uses to base that on. There are no direct fiscal impacts to the Housing Authority's plans, but we just wanted to summarize again our very significant contribution to the Crystal View Townhomes. It's at this point, through the city funds and our HUD funds, over $400,000 that we've allocated, and just beginning construction. So this is something we've been working on for some time. There is timeliness on this review. It needs to be done in December each year. So we have the resolution. I know that Charlie has some questions. Some I can answer, and some the Housing Authority staff will attempt to answer.
I wonder if we should ask the Housing Authority staff to come up to receive questions then, also. Mr. Bland? Okay.
Here, go first.
You do? All right. There are questions. Okay. Okay. Mr. Glenn, did you have like general comment, or we have some questions that council is, I guess, ready to ask? So.
I guess I'm really would just like to respond to whatever question you have.
Okay. Then Charlie.
Okay, well, I put 8 questions together. Some of them are short, some of them are long. My apologies. The long ones. Well, the long ones are the good ones. What's, now that Crystal View is going, I know there was talk of different things being done in terms of passive energy, so if you could review for me what is finally being done. Geothermal was on the list. Is that actually going to happen at Crystal View?
Well,
and could you give us your name again?
okay, well, I'm Patty Smith.
Patty Smith. Okay, thank you.
I don't know. I don't know where they are with their geothermal. Do you know, Libby?
Well, I know that there was a grant that the developer, Brinshore, got from the state, and it does include a variety of energy efficient measures. I can check the building plans to make sure they're all still there. As far as I know, there's geothermal, there's a green roof on part of the community building, and there are also some solar cells on some of the buildings as well. So those are all part of the proposal. I believe there's other structural things that they're doing to achieve those high performances, but this is pursuant to a grant. It's not a Housing Authority grant, and the development is a Brinshore development.
It's to Brinshore. Okay, yeah, I guess I'm more, the question was asked of me, what other passive energy design type things were being done, what other technologies were being incorporated besides the ones that we sort of knew. And so it'd be, okay, and I'll just let you get me an answer on that.
Yeah, and we can come back with that. It's pretty exciting. There's a lot of things on the site as well. There's some lighting that you would be interested in, and
I know about the lighting,
and some drainage accommodations.
I left the lighting out because I know about it. So,
but we can come back with some more information for you on that.
Okay, so more. Let's just to talk about Steer Place. Now, you mentioned about going to seniors only, and so are any individuals being displaced from Steer Place, and if so, where are they going?
No one will be displaced.
Okay, so you've already converted it all to senior only.
No, we have not. We have not gotten HUD approval yet.
Oh, okay. So, but there are no non-seniors in the house.
There are non-seniors in the house.
There are
many non-seniors there.
Okay, so what would you do with them? And
they are staying.
They'd stay?
Yes, they are grandfathered in.
They're grandfathered in. Okay, I see. Okay, so as they would move out or whatever, then, okay, I see what you're doing. Okay, thank you. Okay, when Lakeside was torn down, we lost 98 homes that served the poorest members of our community. We compromised as a council, previous council compromised with the idea that there'd be 80 replacements of some kind in the communities. With construction and senior housing, it looks like you've got about 34 I'm still not seeing the rest.
Okay, I can respond to that question. Actually, you have the 34, as you can see, but also you have 99. Remember, when Lakeside was demolished, we received 99 vouchers.
Okay, you're saying you got 99 new Section 8 vouchers. Those are
Yes.
new on top of everything else.
Correct.
Correct.
So there was, which means, when you look at it as a whole, you now have more subsidized housing today than you had yesterday. Because what you're looking at is the physical that you can see, but you got 99 vouchers, those additional vouchers. The voucher program put in this community over $10 million a year in revenue to private landlords to house our families.
Okay. Okay, so that's, okay, Libby and I can talk about the actual numbers later then. Okay, how is the loss of the Urban League and Homestead managed housing being addressed? How is everybody handling that?
John has been working on this. We may need to follow up with you. These are not, Homestead is doing well, no change in their program. In fact, they're a partner with Bridgeshore on Crystal View Townhomes, so no change in their services. Urban League, their Housing Development Corporation, is fallen victim to the overall organization. But we do, in working with other agencies, we are going to be handling all those programs. So there is a response. John Schneider's been working with HUD, the Regional Planning Commission, and with the Urban League staff to accommodate all those programs. So we can provide you with a report on that. In terms of their Park Place and Crestwood Manor properties, which were two that we assisted with, those have now been deeded to their banks. But there are affordability requirements that run with those units. And yes, but those will likely be purchased by other, that's a short-term process. That was a deed in lieu of a foreclosure. So that has already changed hand. I know Crestwood is Hickory Point Bank, a local bank. But we can get back to you on, it's a very good question. It's something we've been working hard on because they were a very important CHODO for us. So it's quite a loss for us, and we've had some, just some things we needed to do in response to that. So I'll get those written up for you.
Okay. I guess the issue that most concerns me is related to Dunbar. A couple of years ago, you submitted to the city an annual action plan that included elimination by sale or otherwise of all 16 of your scattered site houses. The reason given in the plan was that those houses are 4 and 5 bedroom units, and you said the demand for larger units no longer exists. The current public housing waiting list has 3 families waiting for a 4-bedroom and only 1 family waiting for a 5-bedroom, and so that supports what you said several years ago. But your plan now calls for the demolition of Dunbar Court and replacing it with 4 and 5-bedroom units. If you need 4 and 5-bedroom units, you should have kept the scattered site houses. If you don't, and it appears you don't, then why would we support demolition of needing housing to create housing for which there's no need? On page 10 of your long document, you list the number of people on your waiting list for public housing. 35 need 1 bedroom, 8 are on the list for 2, 3 are on the list for 3, 3 on 4, and 1 on 5. So your data shows that there's no demand for 4 and 5 bedroom units. So why is such a move being proposed? Are you trying to get into the student rental market? This is north of campus. Are you trying to follow the model of putting unrelated people in bedrooms of these units just like they do in some of the student rentals? It just doesn't make sense where you're headed with this.
A couple of years ago, when we first, remember this plan, five-year plan go back many years, and we all know that year to year, your demographics may change from year to year. What you may write today, it may change. To answer your question, as of the day I do the wait list, we just closed our 2, 3, 4, and 5 bedroom wait lists on November 25th. We had it open for roughly 3 weeks. Presently, as of the day, we have over 50 folks on the 2-bedroom wait list. We have 35 on the 3, we have about 23 on the 4, and we have 5 on the 5. And the one-bedroom, we still have that open. What I did, I brought some drawings, just because, once again, in doing your plan, as you can still hear me, you're always planning for the future. That's the most important thing you must remember in the 5-year plan. That's why HUD had the 5-year plan. We're planning for the future. We can't assume that what we have today is going to be what's going to be tomorrow. For example, this is Dunbar Court, for example, planning for the future. We just want to be in a position so that we know that there'll probably be some money coming out in 2010, but if we don't have it in our plan, then we would be left out. It's not that we just want to make sure that whatever we put in our plan, when new money come out, the Housing Authority of Champaign County will be in position to take advantage of it.
Yeah, well, you've got, by your known numbers, you've got 85 families needing 2- and 3-bedroom houses, and yet you're going to eliminate, 25 units roughly that meet that demand if you switch to all 4- and 5-bedroom units.
But our scattered site units, we're going to put duplexes back on it, so the net increase would be 4 more units.
Okay.
We have 16, so that'd be 32.
So you're going to have 32 duplexes.
And there's 26 units at Dunbar Court that we would demolish. Right now, the 4- and 5-bedrooms that we would replace them with, it looks like we can get 14 on the site. That has not been designed, but looking at what the density might be, 14 units seem to fit well on the site. So we're 14 units of 4- and 5-bedrooms, 32 units of 2- and 3-bedroom units to go back on the scattered sites. So the people from the scattered sites units would be moving to the Dunbar Court area.
I just wanted to, with our occupancy, these would be family units, or so the 5 bedrooms would be for large families?
Oh, yes. Yes. And structurally, well, we looked at selling our scattered site units. You're absolutely right. But we wanted to put them in good repair. We're selling them to people who do not have large incomes that can support home maintenance. So when we looked at what it would take to put them in good repair, we found that they were structurally deficient. It did not make sense to bring them up to standard to sell. So the best thing we can do is demolish and rebuild for the scattered sites.
Okay, so I guess then I didn't see a reference to that rebuilding and expansion of the scattered sites in the same way. So I'd appreciate getting a spreadsheet maybe of these are the numbers we expect to be working with in the next couple of years, shifting back and forth, and that would be great. Thank you. I guess, just to follow up then, my bottom line is what is the Housing Authority doing to address the increased numbers of homeless children that we're seeing in the county? In the last couple of years, we've gone from 110, 120 homeless kids in our schools to over 270, as I understand it. And so, what you're telling me is that you are, in fact, trying to address this need. And so in those numbers, that's my bottom line, is are we addressing that need of 270 homeless kids out there and expanding the housing available to those families to make sure that they have a roof over their head?
Well, to answer your question, the Housing Authority will never be able to address all of the homeless needs in the community because, for example, we have a cap on the number of public housing units we can carry in our inventory based on federal regulation. We have 433 today. We can only go to 607. That's our cap. So as the homeless population continues to grow, we have a ceiling on what we can bring back, and that's by regulation. So you would have to have step up to the plate other organizations to fill that void beyond what the Housing Authority would be able to do.
But you're at 433 now?
Correct.
And your cap is 607?
Correct. That's
Okay,
the cap.
so basically what I'm saying is okay, so Well, let's get to that 607 then as fast as possible.
Well,
Probably,
that's the idea.
Yeah, the problem with getting to that as fast as possible is going to depend on money from HUD. Because you got to remember, and that's our goal to get there. But can we say it's going to happen today or next year? I would have to say probably no. But we know that as time go on over the years, we will get there. But it will not happen in the next 2 years. I do know that based on funding.
Well, you just said that in 2010, there's, you expect to see some money, and if we don't have it ready to go, if we don't have the ideas on paper, it ain't going to happen if we're not ready. And so it strikes me that we need to be as ready as we possibly can. And if there's a way to design a system that addresses 607 as your cap, then we should be in position for it and say, here's our priorities. This gets us to 607, and as money comes available, we go for it as fast as we can. If it takes 5 years because the money's not there, that's fine. But we're ready for it in 2 years if it does happen. And that's my point, is that let's get ready for what might be coming down the pike. Public Works is getting ready with its road projects and other projects. We need to get our energy efficiency projects lined up. We know it's going to be competitive, and there are a lot of opportunities out there, and it's going to take local government working with the federal government to get these things done.
Okay, thank you, Charlie. Mayor Pressing, and then Brandon Bowersox.
Hi, Ed. I wanted to ask you about the 607, is that units or people?
Units.
Okay, so that would be enough to cover
That's
the homeless children that we have now, if we could get the money to do it.
Right.
Okay. Then the other question I had, when you say about adding 3 apartments at Steer Place, how do you add 3 apartments at Steer Place?
Well, at Steer Place at one time, and Robert was with the Housing Authority, we had an administrative office at Steer Place. We're going to take that space and be able to put 3 apartments in that space.
Yeah, there's 2,100 square feet there, and it's not being used as office, so.
Okay, and Brandon?
Yep, we're going to take your office.
Ed, thanks for your letter about Lakeside and the 25 units at 30% commitment. I had asked Libby and got a copy of it a number of months ago when you sent it, and I appreciate you all sticking to that commitment, so thank you for that one. I just have one question tonight about Dunbar, which is, with Lakeside, if we could have done it all over again, the things, at least from my perspective, that would have been great are if we could have demolished and had a plan and had a building and gotten it built and, repopulated quicker. It was something like 5 years now. I think it's been about 5 years maybe that it's sat vacant, and I'm so glad finally this month we're going to start construction. But shortening that window so that more units can be there, and I know there were vouchers, I know there were 99 new vouchers, but so that more units could be there and people could move back to their neighborhood and less displacement for children who have to go to a different grade school or make new friends in a new neighborhood kind of thing. So with Dunbar, what are your plans for that? How can Dunbar be an even quicker turnaround or a smoother transition for your residents, for your clientele, than Lakeside? And with Dunbar, is it going to be the kind of funding that's real competitive, that it could take any number of years, or are there ways that we can make it shorter and a smoother transition for people?
Well, I see Dunbar, when we demolish Dunbar, having money in hand as we demolish it, let's say the spring of 2010. By the fall of 2010, starting construction. At the same time, so that when we demolish Dunbar, we also know we have the money to start construction following the demolition. So the time period will not be as long. Also looking at Dunbar, as Libby mentioned earlier, we're hoping that as we redevelop Dunbar, that there are some single-family units adjacent to it. We would like to be able to maybe have enough money to purchase those units so that we can add additional units over on that footprint beyond the 26 units there, I remember? It's 26 units there now, so with the footprint, we're hoping maybe we take it to 30, 35, or even 40 units. If we're able to acquire those single-family units close by, you have a few units that are boarded up close to Dunbar. So we want to rebuild that community to that. But most important thing is not decrease the units that are there, but increase the number of units so that you wouldn't lose any units in the redevelopment of Dunbar. That's the most important fact.
Libby Tyler?
Now, this will be public housing, not a private development. Part of the Crystal View was finding the developer and then that whole financing effort and waiting for the tax credits. So if it's public housing, it's really just a HUD-funded replacement.
We're hoping that we will be able to just make this 100% public housing and no mixed communities, so you will not lose any of the public housing that you have at this time.
Okay. Thank you. I really appreciate that, and especially on the timeline and on displacing people. That sounds really ideal to me, that before you pull the trigger on demolition, you've already got a plan and got money in hand to know what's going to happen next, so people can be back in their neighborhood sooner. So thank you.
I've got a question.
I was going to suggest, for those of you who want a good view of this from the air, there's a very, Microsoft has a new basic map site that competes with Google Earth, and it's livemaps.com or something. I think it's livemaps.com, or I'll send around the link. It gives you a very good view of this area of Dunbar Court, Douglas Park around it, and the houses that are immediately adjacent here, and how, you know, this could be an expanded site, and with a variety of different kinds and sizes of units. You know, because what I was going to suggest is, if you're going to expand, you know, yes, you might need more, you know, 4 and 5 bedroom units, but let's keep those 2s and 3s in the mix as well, if at all possible.
Okay. And I've just got a question for you. How are the demolition charges or costs covered when you have this redevelopment with HUD? Does HUD absorb the cost of taking things down as well as the replacement of them? Or do you come across these funds separately? Obviously, it adds to your fund needs, so I'm asking this.
Well, the demolition funds for Lakeside Terrace, for example, were Hope 6 demolition funds, as well as for Birch Village when that came down. It is a HUD-funded program.
So they do have like a demolition project.
Sometimes, some years they do. So but it was a demolition-only grant. Hope 6 also provides construction, but not in that case.
I see. So you're thinking that when these funds are available for Dunbar Court, you would take advantage of those as well, maybe?
Yeah, and there could be new programs. We're hopeful.
Okay. All right. Any other comments? Okay. Okay. This is a resolution. I guess we can just send it to council for approval or whatever. Is there a motion then concerning this?
Second.
Robert Lewis, second by Lynn Barnes. Okay, those in favor, please indicate by saying aye.
Aye.
Aye. And those opposed? Okay, that resolution is forwarded to City Council. Ordinance number 2008-12-139, an ordinance annexing certain territory to the City of Urbana, precisely called 2003 Airport Road, the property of Delbart and Sarah Dahl. We've heard this before, and Lisa.
Sure, I'll just do real quick. You understand it was done, this is a follow-up to your motion in early November to allow them for sanitary sewer hookup because of failing septic. It's a straightforward annexation, it's contiguous, so it will be converted from R1 in the county to R1 in the city. Any questions? Do you have questions?
Sure. I'd just like to move this to the council with recommendation for approval.
Second.
Okay, moved by Heather, seconded by Charlie. Other discussion? Seeing none, those who wish to indicate approval, please indicate by saying aye.
Aye.
Opposed? Okay, that's moved to City Council. This takes us to two final resolutions. Thank you, public, for being so patient. We have people who'd like to speak to these. First, let's read this. Resolution number 2008-12-026R, a resolution to provide financial reporting on the Internet for the City of Urbana, Illinois. Charlie, this is yours.
Well, I'd like to hear from the public here. This has been out there. I mentioned it last week, and I will have one whereas I'd like to update when we get to discussion of it.
Okay, we have two people who have indicated they'd like to talk about transparency, the issue concerning this resolution. First, Mr. Wayne Johnson.
Thank you very much. Wayne Johnson, 1810 South Vine Street, Urbana, Illinois. The good government is that which is responsive to the people and promotes the general good, and the purpose of which is to secure to the people the blessings of liberty, life, property, happiness, and security. And it's often said that good government is that which does the least. And then finally, whenever people get ready for it, the government wouldn't do very much at all. But what we find is that time goes on, our government, instead of being small, it becomes large. Instead of promoting the ideas of liberty, it becomes authoritarian. And instead of becoming self-sufficient, and it becomes expensive. And the costs in these days, costs are escalating dramatically. And revenues, we don't really know what's going to happen with revenues. I don't think that, Urbana doesn't have gold mines or oil wells, and the government runs off the backs of the people. Are we looking at tax rate increases? How are we going to continue to support all of the things that the government is doing, some of which I'm not sure that the people want done anyway? But good democracy is that which the people are able to participate in, and really appreciate that the City Council has listened to the people in this matter of transparency, and is promoting the idea. And very thankful to Mr. Smith and all of you who supported transparency during the discussions that we had last spring. I really appreciate your inputs and help. And it kind of gets back to Steak and Shake. They said inside it must be right. If the people can see what's going on, then it must be okay. And whenever we can't see what's going on, then we get to wondering why we can't. And thank you very much for what you're doing.
Okay, I just want to correct one thing. It's the third time tonight. My last name is pronounced Smythe. Pretend there's an E on it. It just, the way you pronounce it just depends on what part of Ireland your ancestors come from. So, so people know. Pretend there's an E on the end of my name, and you'll pronounce it right.
I'm not even sure what I said, but it's okay.
Yeah, it's Smythe. It's not Smith. It's
okay.
Smythe.
All right.
Just so people know.
Thank you very much.
Okay, and there's one other individual who would like to do public comment on this issue at this time, and that's Diana Visick.
I'm Diana Visick, and I still live at 608 West Pennsylvania Avenue in Urbana. We've been making great progress locally with governments becoming more transparent. It's really wonderful, actually, to be in Champaign County at this time. Champaign County itself was recognized last week by the Sunshine Review of this Sam Adams Alliance as being having the second most transparent website in the state of Illinois, the county with the second most transparent website. They have all kinds of contracts and financial information there. It's really quite astonishing. And we've also been talking to the city of Champaign about becoming transparent, because 87% of the voters in the election approved the advisory referendum saying that they wanted their stuff posted. We've talked to both Champaign and Urbana school boards, to Parkland College, to the Urbana Park District, and these are just the ones that I happen to know about. And Urbana, the city of Urbana, has been a wonderful leader in doing this and just deciding that they would do it without further ado. And Ron Eldridge has been great in posting things. There's more to do, but he is definitely in progress, and in working with Charlie on this ordinance. I think the ordinance is important because it codifies what's being done. It makes it clear that we commit to continuing to do this into the future, no matter who is around in terms of the council, no matter who is mayor, no matter who is controller. We still commit to doing this. We think that it is that important. I think that's very important. And it serves as an example to others to other communities, to other cities, that this can be done, that this is the kind of thing that needs to be done, and the detail of the ordinance is useful. It says, this is what we consider to be the definition of transparency. This is the kind of information that needs to be out there, so that other cities who are looking to do this can figure out what to do and can look at your ordinance as an example to guide them in doing this on their own. Because there's some people who are not as self-starting as the city of Urbana is, and actually do need this guidance. And I hope that in the future that the Sunshine Review or other similar efforts recognize Urbana's leadership in this, and that we get awards or other things for Ron and for the City Council, and that prove to the rest of the world what leaders we are. And I thank you very much for considering this ordinance, and I hope you pass it. Thanks a lot.
Okay, those are the two, yes.
I just have a question for Diana.
Okay. Heather has a question for Diana. Wait a second.
Diana, is there anything that's not being reported now that you're asking for to be reported?
There are more contracts that need to be posted, but I think it is listed in the ordinance that contracts will be posted. So I think that this is pretty much what needs to be done. Ron has said that he's developing other reports like revenue projections and stuff like that, which he is certainly willing to share. I don't think it has to be put in this ordinance. The stuff in the ordinance pretty well covers.
It's actually a resolution, just for the...
Okay, resolution. Thank you. I have confusion with these things, so.
Okay, that was my question.
Okay. Mayor Pressing.
How much time have you spent looking at our financial data that was added in April?
I have actually looked at some of it. The projects that I am working on at this instant do not require that information. In Champaign, they were about to, because I was just talking to them about their decision to stop salting secondary roads while they were continuing to provide police escorts for high school football teams going to the Illinois High School Association tournament. And I thought that perhaps we should have a review of what was an essential government function and what wasn't. And it's not, I do want to assure you that you're not doing this for me personally. That sometimes I need this information, sometimes I don't. But I'm requesting this for others who have other projects that I could never dream of that need this kind of information. And at the moment, frankly, I'm dealing with basic transparency issues for other sorts of units of government, like Parkland College, who just wants to put out an $87 million bond issue and doesn't really want to talk to the public about a lot of these things. So my personal activities politically should not be taken as, indication of the value of this.
Okay. I would like to ask, is anyone in the audience has looked at the information that we've put on? Okay, Mr. Johnson has. Is that Johnson or Johnson?
Mr. Johnson, yes.
Not Johnston. Okay, well, I'm opposed to passing an ordinance or a resolution because we are already doing this. And I noticed there was a gentleman here earlier who is still mad over being outvoted in April at the township election. And I know that Mr. Johnson thought that what happened that night was fascism. I remember you saying that. I'd like to say,
I remember too.
Yeah, the City of Urbana has been providing financial reporting on the Internet for a number of years, and these reports include the budget and the annual financial report. In addition, the Comptroller has reported expenses by vendor in the annual Treasurer's report, which has been published in the News Gazette for as long as anyone can remember. That's all the expenditures by vendor. Last spring, Ron Eldridge began putting the detailed trial balance on our website as well. This was done in response to a small group who wanted to put a referendum on the ballot to require such reporting. I assured the group that the city would provide the financial information on the website and that a referendum was not necessary. I asked if anyone had ever been unable to get financial information from the city. No one said they had ever experienced any difficulty. And I would say in my 16 years as Champaign County Auditor, we were happy to provide financial information and made sure our reports were made available at the library as well as in county offices. During all those years, not one person ever complained of a lack of access to financial records. After the city put more detailed information on the website last April, the proponents came back and insisted that we also needed to pass a resolution. The only rationale offered was that at some future date, the city might discontinue making the details available on the internet. Clearly, this is not an issue of access to financial information. This is an issue of a political party trying to promote itself by repeatedly pushing its view that Urbana government is not open and transparent and is not democratic, and that voters should vote for them instead of the current people in office. The individuals who are pushing this do not hesitate to indulge in name-calling when others do not agree with their ideas. For example, they publicly called current officials incompetent and cowardly for deciding that 1,000 signatures on a petition did not satisfy the legal requirement to submit 2,000 signatures. They have repeatedly called Urbana government fascist. They are entitled to promote their political views. They should not expect the city council to do their campaigning for them.
May I comment?
Yeah, go ahead, Diane.
The first three things that you listed as being posted actually are required to be made public by state law, so that was not anything in addition. The things that Ron Eldridge...
Not public on the internet, okay?
Well,
we put things on the internet that are, we have always gone beyond state law. And I think I understand what you're doing. You're coming here and being very nice to us tonight because you think we're going to pass your resolution. But in the past, it's always been how we're undemocratic and how we're authoritarian and how we're fascist. And I'm getting a little sick of it.
Okay, thank you. Other comments from the City Council? Charlie?
Well, I'm waiting for us to finish with Diana so she can go back to her seat so we can take up the resolution.
Then, she gave a presentation, and
Was there any
we're
other question?
merely responding with our questions to Diana.
Okay, well, I don't have any questions for Diana, so.
Okay, then, thank you very much, Diana. All right. Those are the two individuals who wanted to speak on this topic at this time, so comments about the resolution? Charlie, would you like to start?
Yeah, I feel differently than the mayor. I'm going to divorce my personal feelings about the individuals involved and so on. 3 years ago, we came onto this council, or 3.5 years ago, about 3 years ago, we decided the website really wasn't serving the city of Urbana very well. And 2 years ago or so, we authorized a change in that website. And all this time, we're saying, you know, we've always said, let's get as much information out there as we can. We did electronic packets. We Ron started adding his stuff. The mayor encouraged everybody to put stuff on the web. There's no question that we are way ahead of the curve in the state. What I'm after is setting an example for the rest of the state, because I think this is good government, period. Doesn't matter who it comes from. Who suggested it? We suggested it ourselves a couple of years ago. Okay, and that's why in April, the mayor and I were both saying, we already do this on the web. We don't need to do a referendum because we're already doing it. And I also committed myself at that time to putting this forward. We passed a resolution at the township board level to do essentially this same information. So we would be inconsistent to not have policy at the city council level as well for the city. So to me, it's more about this is good government. This is the direction states should be going. This is the way states are going. The Freedom of Information Act, the Open Meetings Act already requires us to put certain things up on the internet. I figure it's just a matter of time before they require all of this information anyway. We might as well set the example, and this gives us bragging rights, okay? We're one of the first to do this, period, and it's our policy, and that's what I'm after. So along those lines, I would suggest that we change the fifth whereas to make it a little more clear, and I'll share this with the clerk. The fifth whereas I would propose changing to whereas the city is currently updating its website and already takes advantage of modern communication methods, publishing to the web as much information as possible, including the below-mentioned financial documents in a convenient fashion to city residents. So that would be my substitution for the fifth whereas, which recognizes what we've already been doing in a better fashion. Thank you.
Okay, is there general discussion? Lynn Barnes.
I guess I would just say that if what we're after is an example, we've already got it, because people can get on the internet and see all this information. I mean, it's evident. The proof is in the pudding. So I think that's one thing. And then secondly, I think there was something different about the township resolution than this.
Okay, Mayor, comment on the difference
The
between
township was not putting stuff on the internet.
at all, yes.
That was the difference, and the city has been for years.
Yeah, that's true. And
Go
Lynn?
ahead. That's right.
Okay, that was a comment. Other comments or discussion? Yes, David. Here.
I'd like to suggest an alternate to your alternate whereas, so that this would be, this would replace the same one you just suggested replacing. Whereas the city practice and policy has long been to fully comply with these acts, and the city has in fact exceeded the requirements of these acts and encourages the other Illinois communities to do the same.
I would, if I could be recognized.
Charlie?
I would move the resolution as amended by David.
Okay, to adopt the whereas number 5 as
the
converted?
as I would move the resolution as proposed by me with this change to the fifth whereas.
Okay, so we're having a motion on the resolution with the amended number 5 whereas. Do we have a second for that suggestion?
I'll second that.
Okay, so, wait, Charlie, who made the motion? Charlie made the motion for his own resolution, okay.
Can I?
Charlie, yes. Heather?
Originally, I was not in favor of this resolution because I feel like we're already doing stuff. It's just one more thing that I thought was kind of unnecessary. I can be supportive of it with the word change that David's proposed. Like I said, I wasn't 2 minutes ago supportive of this, but with the word changing that David has proposed, I am more supportive than I thought I would be.
Okay, I've got a question for Charlie. Your item number 2, which requires the city to make a detailed report by date, amount, description of every payment of city funds made by the city except where disclosure of the identity of the payee is prohibited by law, entitled Detailed Trail.
Yeah, we already do all of these things, essentially.
Okay, we do that as well.
We do all of these things, and in fact, that thing that gets published, the thing is, if we put it to paper, if we're publishing it in the newspaper, it's a trivial matter to publish it to the web.
Okay. The other, number 4, you limited the reports which are concerning total funds paid by the city to payees to a $2,500 limit. So I'm wondering why then on item number 2, you exceed that $2,500 limit and make every single payment posted by the city. In other words, the complete books of the city and all its funding. Is that what you're intending?
This is working with Ron Eldridge on what he currently puts out there. So I'm dependent on him to provide me with the wording on this, and this is what he tells me he's currently doing.
Okay.
So I can't really.
I'm just wondering if there's a good working limit.
Well, the thing is, this thing called detailed trial, I think, and I think there's some accounting things in here that maybe Diana seems to know the answer. If she could.
Well, I'd kind of almost like to get the answer from our controller rather than a person in the public, but.
Well, if she knows the answer, I'd just as soon hear it. But
because I've been working with him, The number 4, the 2,500 limit is apparently a state mandated law, so he prepares that report anyway. That's what goes to the News Gazette, okay? So really what we're asking him to do here is just stuff that he does in the normal course of business, not to do anything extra, because we're not looking for an extra workload. Number 2, he prepares a detailed trial balance. He calls it a detailed trial balance and just put in here detailed trial. He does this every month, and this is his general accounting practice. This is how he keeps track of how much the city is spending against every budget line item. And I've looked at it. It's quite interesting. You can find very interesting stuff in there. So really all he's doing is taking the stuff that he normally does and just posting it on the web.
Okay.
And that's where that discrepancy comes from.
Okay.
Thank you.
Okay. Other comments or questions? Brandon, did you have one, or were you making a? All right. Then there's been a motion and seconded that the resolution be adopted.
Move forward to council.
Move forward to council. Okay, that's what I really mean. Any other discussion? All right, I'm going to take a vote then. Those in favor, and this also, this is with the new whereas number 5 as proposed by David Gehring. Those in favor, please indicate by saying aye.
Aye.
Okay.
And those no.
And those indicating no?
No.
Okay, and I'm going to say,
That's not
4 to 2.
everybody. Oh, okay.
I'm going to say nay.
So 40. So 3 to 3. Oh.
Okay, show of hands. To forward it to council as written, it currently written. Those in favor, raise your hand. 1, 2, 3, 4. Okay. Those opposed, 1, 2. I think I'll say. All right. All right. It has a majority, so it goes forward to City Council for final approval. Okay. Resolution number 2008-12-127R, a resolution in support of the Employee Free Choice Act. Mr. Smythe, let us know about this one.
Yes, do we have anybody yet to speak on this?
We do. We've got a pile of people who would like to
Okay.
speak. We've got 3 individuals who would like to come forward.
I'd just like to point out that this is an item supported by many of our legislators and President-elect Obama. It comes from another constituent, as did the previous, and I strongly support it, and I'll speak to it after we've heard from others.
Okay. Those who wish to speak to it at this time are the following. Ricky Baldwin.
I am Ricky Baldwin, and although you may be feeling that you live here, I live at 801 East California. I wanted to talk about this resolution because I've done some work with unions quite a bit over the years and have some knowledge of the reality of the statistics that go on in the efforts to form unions in the country, and I've also done quite a bit of writing on unions and have interviewed people, so beyond my direct experience. I just wanted to tell a couple of quick stories, maybe, about the fact that highlight some points, which are most Americans don't really understand what labor law, how it works in this country. They don't. Most Americans, I think, don't know that, for example, if you don't have a union in this country, you can be fired for any time, at any time, for any reason or no reason. That's the way the law reads in most states. So you could actually be at a job for 15 years. You could get a new supervisor who doesn't like the color of your socks or whatever. You could be fired for that, and you have no recourse if you don't have a union. You also have a lot of rights on paper in this country. OSHA, for example, has a lot of health and safety requirements. In fact, if you don't have a union, a lot of those are just on paper. because you don't know how to access them, you don't have an advocate to work you through the process, and OSHA is often barred from going onto properties to check out these kind of things without a search warrant or something like that. So it is very difficult, and if you don't have a union, there's a lot of intimidation that goes on surrounding things like calling OSHA. But in this country, poll after poll says that most people would join a union if they had the opportunity. However, a little more than half of the union elections in this country fail. Why? And the reason is because there's a length of time in between employees petitioning for a union and voting on a union that gives the employer an opportunity to intimidate and harass and otherwise play with the numbers. I worked with a group of workers in another city. They were laundry workers. Laundry was named Angelica. It's a hospital laundry. And these workers worked in the worst conditions imaginable. They opened bags of laundry that contained blood or feces, sometimes human body parts, sometimes needles with, they had no idea what on them. They were provided no personal protective equipment, no gloves, nothing to handle this material. They stood in pools of water, electrical cords in the water, sometimes frayed. They would get shocked while they were at work. The laundry was delivered to them in overhead, a kind of conveyor system with huge bags of laundry in excess of 100 pounds that would sometimes fall. And if that fell on a worker, they could be seriously injured. The hooks that carried the laundry would also sometimes fall, hit them, and chip or fracture bones even at times. And they were sexually harassed while they were there. There were a lot of things that went on. These workers, when they attempted to form a union, were mercilessly harassed, as you might imagine in that situation anyway. But the management hired a union-busting law firm to intimidate them. Your employers are allowed to hold single one-on-one meetings with employees, mass meetings where they're required to sit and listen to intimidating talk against unions, threats to close down plants. There are a lot of things that management does that are actually illegal, but because the process is not set up to make it easy to get recourse for those things now, employers do them all the time. They fire employees. They fired some employees at this laundry. They introduced new workers to the bargaining unit to dilute the vote. You can hire friends or family members. Employers sometimes illegally change wages or working conditions in order, sometimes to make the bargaining unit uneven, to sow jealousy. There's all kinds of things they can do. I worked with a group of workers at an adult home, also in another city, where the employees voted overwhelmingly for a union. And 3 years later, it still wasn't recognized because of legal challenges that the employer held up. I talked to those workers myself, and the vote was overwhelmingly in favor of the union. These were frivolous lawsuits that employers have access to now just to hold up the process. The effect on communities can be terrible if you have a significant number of people working in these kinds of conditions and in these kind of tenuous environments. So it is important to local communities the fact of whether or not members of their communities have these rights.
One more minute.
Okay, thank you. In the state of Illinois, as you may know, public employees recently have the right to what's called card check, which the Employee Free Choice Act would provide. In other words, if you just get a majority of the workers to sign, then you get your union. That's what they do in some other countries, and it works fine. I want to thank Charlie for introducing this and for you for hearing this. I want to say that another important reason to do this in closing is that there is enormous pressure on the Congress right now and on the President not to pass this law from employers like Walmart, who want to keep their workforce union free. And that's the reason it's important for communities like this to step forward and say that this is important to us. Thank you.
Okay, thank you. Ricky, are there questions for Rick? Okay, are pressing?
Our information supplied by Charlie from Wikipedia, the unimpeachable source. But I just wanted to ask you, the House of, according to this report, it said in March 2007, the House of Representatives passed the act by a vote of 241 to 185. And then in June, the Senate voted 51 to 48 to invoke cloture, which we hardly ever invoke around here, by the way. But anyway, what I wanted to ask you is, if this Congress is not going to pass it, I would imagine that the House of Representatives and the Senate will pass it in the next Congress. Our congressman is not in favor of this. The only person that's going to listen to a resolution from Urbana would be our congressman. So what do you expect to gain? I don't think he's going to change his mind. And we need him for a lot of other things, so why would we want to get in a fight with him over this when his mind's already made up and the bill's already going to pass?
Well, I think the bill's passed when it's passed. But I'm not proposing, I don't think anybody's proposing we get into a fight over him with it. And I don't think that it's unusual that he listens to his constituents. I think sometimes he does. And, when I think we have an avenue, this is not the only thing that we're doing to get the word to our elected representatives in Washington that this is what we believe they should do. I don't know what he will do, obviously, but I think it's good that he know what this community thinks, and hopefully he will listen to that. I mean, he's done it in the past.
Heather Stevenson?
I would like to make a statement, and that is, I don't believe that this issue.
I thought she was going to ask Rick a question. Are you going to ask Rick a question?
I was going to ask him after I made my statement. Okay. I don't believe this is a city council issue, and I didn't believe that the chief, Alina Wick, was a city council issue. And I'm wondering why, when you do have a congressman who doesn't sometimes listen to his constituents, but always listens to his constituents, whether you agree with him or not, he always listens to his constituents, why you believe that this is something that needs to come from the city council to your congressman.
I'm not here to talk about the chief, but as I said, I think that this is not the only avenue that we're pursuing to get that word to our congressmen and senators. But, it is an important issue that impacts the community. Because we had a speaker earlier who spoke to a local employer who was doing some pretty serious union busting. And it affects employees who are members of the community. And that's an important issue for the city council to address. If people are being fired unlawfully, if people are not able to achieve the working conditions that in a civilized society we expect, that has a ripple effect on the whole community. And I think that's why it's important for the city council to take it up. But it's not the only thing. As I said, we're collecting postcards. We're doing other things, and this is not, hopefully not the only city council that we will be talking to about this.
We have two other speakers here waiting to speak. Let's try to get onto those people.
Thanks.
Thank you, Rick. Also wishing to speak on this issue is Robert Neerman. Is that correct? Neiman. Alrighty.
But I don't care how you pronounce the name.
I could have said something else, but your handwriting was very, there might have been a Z in there, so I decided not to use it.
Well,
go ahead, Robert.
You're my alderman, so you should learn my name.
I will.
Just kidding. My name is Robert Naiman. I live in 802 East California, across the street from Ricky in Ward 5. And I work with Jobs as Justice, Central Illinois Jobs as Justice, which is a community labor coalition, national community labor coalition, but we have a chapter in East Central Illinois, mainly in Champaign-Urbana. We advocate for worker rights, so obviously this issue is very important to us. I want to thank Alderman Smythe and the other members of the City Council for allowing this to be on your agenda for consideration. I'm actually quite hopeful that labor law reform will be passed by the new Congress, and certain that if it's passed by Congress, it will be signed into law by President Obama, because he's promised to do so, and there's no reason to doubt his word on this. And I'm sure that if it is passed, it will be in part because of discussions like the one that we're having here tonight. It's conversations like this, I submit, that will convince members of Congress that this is a pressing issue and that action is needed. To answer Laurel's question, this was passed before by the House, and there's no reason to believe that it won't be passed by the House again. The real drama is what happens in the Senate. As you mentioned, when it was before the Senate in 2007, there were 51 votes for cloture. 60 votes are needed. If one extrapolates, we don't know what's going to happen, but if one extrapolates from what happened in 2007, every Democratic senator, including our Senators Obama and Senator Durbin, voted for cloture. Senator Lieberman voted for cloture, and Senator Specter voted for cloture. That's what he was the one Republican who did so. There are now, depending on the outcome in Minnesota, 58 or 59 Democratic senators counting Lieberman, and if Senator Specter maintains his position, that would be 60. So that would be so if that pattern continued, which by no means guaranteed, that would be the outcome. But we don't know how many senators there are going to be. And really the key thing here is showing community support so that members of the Senate will see this as a priority. It's something that people care about. That's why we want to, and people not just in the labor movement, but people who support workers' rights. And that's what we're about here. On December 3rd, the Democratic Central Committee, Champaign County Democratic Central Committee, passed a resolution to support other community organizations in our area have supported, including the Illinois Disciples Foundation and the Channing Murray Foundation, and we are working on others. As you know, in the U.S., as in other industrial democracies, employees have the right by law to choose to be represented by union in negotiations with their employer over wages and working conditions. Unfortunately, the status quo now for too many workers in the United States, particularly in the private sector, is that this is a right that exists in law and not in practice. The purpose of the Employee Free Choice Act is to redress the situation so that this right exists for all workers in the United States in practice as well as in law. There are three key reasons that this right does not now exist in practice in the United States, and the Employee Free Choice Act seeks to address each one. First is the law as it's currently enforced. Many employers do not in practice have to accept a union where there is majority support. As was alluded to earlier, during the passage of time between demonstration of majority support in the form of a majority of authorization cards and election ordered by the National Labor Relations Board, many employers mount very aggressive intimidation campaigns using fear to thwart the will of the majority. This is, of course, deeply related to the second problem, which is that the sanctions currently faced by employers for violations of the law are too weak. In particular, as was mentioned, in the United States, union supporters are routinely fired in retaliation for union organizing. Survey of NLRB election campaigns in 1998 and 1989 found that private sector employees illegally fire employees for union organizing in at least 25% of all efforts to join a union. This is, of course, a blatant violation of the National Labor Relations Act. But the current
One more minute.
current sanction, if the NLRB finds in the workers' favor after much delay, is back wages. This is like punishing someone for stealing by just making them pay back and facing no other sanction. Many employers regard this as a small cost of keeping unions out. Finally, although employers are required by law to bargain in good faith, in practice there's no real punishment for failing to do so, and therefore the goal of first contract can be delayed indefinitely, effectively undermining the right to organize. I believe Rick Prince is going to talk about the situation in Effingham. I just want to mention that in Bloomington, employees of the Pantograph filed for an election at the beginning of the summer. Now, just this week, they're finally going to have an election. 2 of the union supporters have been fired. That's at the Bloomington Pantograph, which one would hope would be under some community pressure, being a newspaper. The Employee Free Choice Act seeks to address these issues by the following. First, employers would be compelled to recognize the union when workers have demonstrated majority support through authorization cards. Second, penalties for employer violations would be increased. Third, if negotiations failed to produce a first contract, then either side could appeal for mediation, and if that failed, for binding arbitration. This would guarantee that workers who form a union could achieve a first contract. Again, Rick Prince is going to talk about the violation of that in Effingham.
Okay, thank you. Thank you for your presentation. Charlie?
I have a quick question here. So in talking about this, I passed around the Wikipedia reference, and some people have told me that it's rather one-sided or whatever.
As an academic, you should know better than
Yeah,
treat
well,
Wikipedia as a source.
Yeah, well, I mean, it was quick and dirty, so
Yeah,
I mean,
no,
it
that's okay.
summarized it, had a lot of links. So
Yeah, no, that's good. So the main criticism in that article, and the main criticism that one hears in the media and elsewhere, is this. The main claim. The Employee Free Choice Act would take away the right to a secret ballot election. And that's false. And this is why it's false. Nothing in the Employee Free Choice Act would change existing law that allows 30% of the workers to petition for a secret ballot election. That would still be true. What the Employee Free Choice Act does is give the power to the workers to decide the process by which the decision will be made in order to have a union. Right now, the employer has effective veto power. The employer can, and some do, voluntarily agree to recognize the union when the majority demonstrate support through union authorization cards. That's current law. But they're not required to do so. Under the Employee Free Choice Act, they would be required to do so. Nonetheless, it would still be the case that if the majority of workers wanted to have a secret ballot election, they could have a secret ballot election. In fact, the law would still be tilted towards a secret ballot election because it only requires 30% of the workers to say that they want to have a secret ballot election. So if 69.9% of the workers would rather use cards and 30% of the workers want to have a secret ballot election, there would still be a secret ballot election. So it doesn't take away the right of the workers to have a secret ballot election. It takes away the ability of the employer to insist on a secret ballot election. And the reason that employers under the current system like secret ballot elections is because, as has been described, it gives currently the filing of cards is the opening bell for the employer intimidation campaign that uses these illegal methods of fear and intimidation.
Okay.
I suggest you get on and make those changes.
All right. Okay, thank you, Robert. Thank you very much for your presentation. We have one more, and Rick Prince. And hopefully, you might be able to avoid any material that's already been presented. If you have any new material to add to this
All my
conversation.
material is new.
Okay, go ahead. You have 5 minutes then. Thank you.
First of all, I'm probably the only person in here tonight that is not from Urbana. I live in Mahomet, 1202 West Diana, Mahomet, but I represent the city of Urbana employees. I'm a union rep for AFSCME, and I represent the employees that Bob was talking about down at Effingham, a facility called Heartland Human Services, that we've many times called Heartless Human Services. The employees there organized their local, and we began negotiating their first contract in March 2006. After bargaining for more than 15 months, and the employer doing, quite frankly, nothing but face bargaining, the employees were forced to go out on an unfair labor practice strike, which means that like I said, the employer continually violated the law, like I said, did what we call face bargaining, did everything they could during that period of time to prevent the employees from getting a first contract. That brings up the point of one of the issues that my predecessors talked about is that the 50% of the elections, the union elections that happen right now, 51%, end up not having an election or not doesn't go in the union's favor. Fully 25% of the ones that of everybody else that does get a vote in favor of a union, 25% of those don't get their first contract. And it's because employers use tactics like what has been used in Effingham at Heartland Human Services to prevent them from getting that first contract. We've been in bargaining. Like I said, the employees went out on strike in July 2007. They are still out today. We're looking at 18 months now. They were out on strike fully that first in an unfair labor practice strike for a full year. The employees offered to go back into work and to still continue to negotiate a contract in June of 2008, and the employer at that point chose not to let those employees that were out on strike go back into work. They said instead that they locked them out until we got a contract. And even when they did that, they still continue to face bargain. We might spend 4 hours once a month in negotiations with them since then. So even though the labor board says the employer has to do these kinds of things, the labor board is not labor friendly, and that's what we've seen time and time again in this. What's happened with these employees down here. So far, the employer has been, and quite frankly, the employer prior to this had been getting about $3 million a year from the state, and now the state is paying the employer to, in essence, in our tax dollars, to keep the employees out on strike, or in this case, out on lockout. The state is paying the employer, in this case, to fight their employees. So far, approximately $350,000 has gone to attorney's fees to keep the employees from having a union. And this facility, I didn't explain this for start out with, but this facility is an alcohol and drug rehab facility. They also do family counseling and therapy, those kinds of things. And they serve a population of Effingham County and some of the surrounding counties. They were, and they serve, it's about 350 plus clients and residents right now are without services because of that. And quite frankly, during that period of time, there has been one striker that has died, didn't have health insurance, wasn't able to go to the doctor to find out what happened. The employee or the striker had fallen and gotten a blood clot, and like I said, wasn't able to afford to go to the doctor to find out what happened. And there was even one client that committed suicide because they was not able to get proper therapeutic care. The business that they have down there is down 70%. All those things are, these are hard, concrete facts of what has happened when an employer continues to violate the law without any recourse. It's quite frankly without any recourse. Like I said, we started bargaining in March '06. You do the math. We've been out there bargaining now for almost 3 years. I'm sorry, almost 3 years now, and without a contract. What the Employee Free Choice Act would do is get a contract. We have 90 days to bargain a contract, another 30 days to get the with a mediator, and then after that, an employer or an arbitrator would institute a contract on both parties, a fair contract, and that's what we're hoping for. And what we've been asking, throughout all of these negotiations, is just a fair contract. We're not asking for anything that's not covered in 99.9% of the contracts that are out there right now, the union contracts. So this is exactly the reason why the Employee Free Choice Act is so important to get passed. We are looking at not only our representatives and senators, but wherever we can to help our representatives and senators make that kind of decision, that this is the right thing to do for workers. When all workers organize, they help bring the standard of living up for the whole community, and that's what should be done. Everybody should have a voice at the workplace, and this is being taken away from them right now by the labor board. That's, as I said, the labor board is not labor friendly.
Okay, and that's about 5 minutes for sure.
Okay. Any questions?
Do you have questions for Rick? Yes, Mayor Prosing?
When you say the labor board, you mean the National Labor Relations Board?
National Labor Relations Board.
Are they appointed by the president?
They are.
So will there be a new group?
We certainly hope so. We hope they'll. I know that we're in the St. Louis district down there, and the regional director down there was he was there under the previous administration, but quite frankly, even under the previous administration, he was a lot more fair to the employees because there is a board there also to make some determinations, and this regional director was overruled by his board several times in previous actions that we've had. But now what's happened is we've seen the board rule against us time and time again. We're on charges that in previous administrations that we found that were found in the union's favor, quite frankly.
Okay. Other questions for Rick? Okay, none. Thank you very much, Rick, for your comments. I'm just going to let you know that 3 other people have indicated that they support this resolution, but do not wish to speak. Joe Futrell from 1205 South Ray Street, Ron Zoke of 105 East McHenry Street in Urbana, and Nancy Dietrich Rybicki at 2803 South Myra Ridge Drive. Okay, thank you. Yes, Lynn Barnes.
I gave Charlie a heads up on this, not so blindsiding, but I think this is an important topic worthy of debate, absolutely. But I don't think it's one that should be debated by a city council. I don't see us right now debating the merits back and forth now for quite a while and come to some compromise. And that's what we do best. What we do best is debate on matters, we compromise on matters, and we solve city problems. And I believe that that is what I was elected to do. So I don't think that this represents the best use of our time. And frankly, we all could have a litany of political positions that we could take and choose to debate. But again, I think our time is best used on city matters. And I've been fairly consistent on that philosophy over the last 4 years. And frankly, I think as a group, we've done well about not bringing those things to city council. And we have stayed focused, and we've done a great job, I think, in many ways, compromising, debating on matters and coming up with good solutions. And I hope we stick with that path, and I urge you in that direction.
Okay, and Heather?
Charlie, tonight I'll give you 1 out of 2. I gave you the last resolution. Tonight I won't. I don't believe this belongs on city council floor. I believe that this is something for our congressman who does listen to his constituents, and he makes hundreds of phone calls a day to his constituents, and he receives hundreds a day that he returns. And I would urge all of you who are in support of this resolution to, instead of bringing it to the city council, to take it to him, take it to his office, because that's where things will happen, not here on the city council floor.
Okay, other comments? Charlie?
Well, we've supported a number of, a variety of federal and state resolutions through the years at different times. Some are more political than others. Some are more immediately obvious than others. They have more direct impact on us. But as they say, all politics is local, and I really believe that. And when state and national policies fail, as we've seen in the number of years here past, it's our obligation to speak up and step forward. I think this is a fairly important issue. There's an opportunity to get things changed, and more importantly than anything, it's an opportunity to help generate a level playing field. That's what I'm after. I don't think we can cherry pick the federal and state issues that we support. We do take care in the ones that we bring forward, and yeah, I could have brought a lot of other non-relevant ones to council, but I think this one is personally important, and as a union member, I just can't help but note that this country's manufacturing sector has gone from 40% to 12%. We are no longer a leader in world manufacturing and other things, and at the same time that we've gone from 40% to 12%, we've seen a substantial erosion in the ability of the worker to combat large corporations. And above it, to me, the only way we're going to solve some of our economic issues is to create a level playing field. And so I think it's important. This is the kind of thing that trickles down to all of us in our communities. And so I would move the resolution as stated in the motion that I brought forward. I don't have the number in front of me now, sorry. Resolution 2008-12-027R, resolution in support of the Employer Free Choice Act.
Is there a second?
I'll second.
Okay. Discussion? I did email Vasilia Clark, who would certainly be the person who would be the key person here in our community, or as far as the city is concerned, to find out whether we supported union activity, union growth, and union formation. And she said we certainly did. And I said, I asked her, so what relevance or importance would this have for us to be commenting on? And she said she didn't know. So I was just trying to make it somehow pertinent to our local government, since it's being discussed by us who are members of the local community here. It's not that we don't know people who are in unions. Of course we do in this community. But if the city is going to be adopting a resolution about fair labor practice, my question is it mostly, should we basically be applying some of these concepts to our own ordinances to make sure that they are appropriate and strong? And it would seem like that would be a good debate to have here at the city, rather than to be passing resolutions trying to affect the national scene on various instances. We might have a resolution coming here forward whether the car industry should be supported financially. We could have a lot of kinds of discussions here in City Council to try to indicate to our national leaders how we feel about these questions. However, that said, I know that my constituents in my neighborhood are very strong, hardworking individuals. Many of them work in industry and work in shops, work in, have home industries or are self-employed. The question of union membership is important to many of them. So even though it's against my best thinking of good practice for the city, I'll probably support this resolution. All right, anybody else? All right, so we're going to take the vote. Okay, those in favor, public input's over with right now. Thank you very much. Those in favor indicate by saying aye.
Aye.
Aye. Those opposed? Okay, so maybe let's have a hand vote. Those in favor? Okay, those opposed? All right, this one's going to go forward. All right. There's no other business upon the City Council's agenda tonight, so I call us adjourned at 26 minutes after.